Good morning, everyone. 7, 8,
Good morning.
9. So that looks like we're at quorum. So I'll check in with Carrie to find out if the video's been started. Says it has. Yeah. And Aaron and Anna are here. So we can get started with this morning session for the Joint Standing Committee on Health and Human Services. We'll be looking at 6, 8 bills, 9 bills in work session today. 2, 4, 6, 8, 9. And then trying to get as close to 1 o'clock as possible for a public hearing on a new bill. Let's start by introducing ourselves around the table. And why don't we start with Representative Connor?
Thank you, Mr. Chair. Good morning, everyone. My name is John Connor. I represent House District 58, which is part of Lewiston.
Representative Craven.
Thank you, Mr. Chair. Good morning. I'm Margaret Craven, and I represent House District 59, which is part of Lewiston.
Representative Madigan.
Good morning. I'm Colleen Madigan. I represent House District 110, which is part of Waterville and part of Oakland.
Representative Zager.
Thank you, Mr. Chair. Good morning, everyone. I'm Sam Zager. I represent District 41 in Portland.
Representative Lemelin.
Good morning, everyone. I'm Michael Lemlin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Noblesboro.
Representative Stover.
Good morning. My name is Holly Stover. I represent House District 89, including the towns of Boothbay Harbor, Southport, Edgecombe, Westport Island, and part of South Bristol.
Senator Baldacci.
Good morning. Thank you, Mr. Chair. I'm Joe Baldacci. I represent Senate District 9, which is the city of Bangor and the town of Herman. Thanks.
Representative Perry.
Morning, I'm Ann Perry. I represent House District 140, which includes the communities of Indian Township, Baileyville, Bering, Calais, Charlotte, Robbinston, Perry, Pembroke, and Pleasant Point.
Senator Moore.
Good morning. I'm Marianne Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Meyer.
Thank you, Mr. Chair. Welcome to everyone joining us today. I'm Representative Michelle Meyer, serving Southern Maine's House District 2, which is all of Elliott and parts of Kittery and South Berwick.
And I'm Ned Claxton, honored to represent the folks in Senate District 20, which consists of Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. We have our staff with us today. Anna.
Hi, I'm Anna Broom. I'm one of the legislative analysts for this committee, and I work in the Nonpartisan Office of Policy and Legal Analysis.
And Aaron's with us too.
Good morning. I'm the other legislative analyst with this committee, also with the Office of Policy and Legal Analysis.
And Carrie.
Good morning. My name is Carrie Withy. I'm the clerk for the Health and Human Services Committee. If you need any assistance today, you can email me at hhs@legislature.maine.gov.
And just before we begin, I want to point out that the recent reports on bills outstanding has us in excellent shape to conclude the session. We will not be contributing to our going late if we have to after the 15th or 16th. So represents a lot of hard work, and I wanted to acknowledge the committee's efforts, the elected members, but also highlight the fact that our staff has been incredible trying to move this process along and help us be successful at this legislating thing. So thanks to Aaron and Anna for their contributions specifically, and also to Carrie for her work in keeping things organized, helping people get in and out of meetings, and all the work she's done. So a round of applause for the staff, and thank you all for your everyday efforts. It's appreciated and noticed. All right, so we have the 9 bills we referred to for work session. We also have several other things to attend to. So I think we'll turn it over to Anna at this point.
Okay, so I just want to start with an explanation of the email that Erin sent you yesterday about the rule review. And I just want to do a quick overview of how this will work. So I'm going to start with sharing my screen to show you the law. To begin with. So hopefully you can all see that. So you can see under the, this is the chapter of the Administrative Procedure Act that specifically relates to, it's a petition process, which is a little bit different to the rest of the rule review, the rules that you're used to thinking about. And I think I had a slide about it, but I quickly skated over it because we don't always need it. So there is this provision in the law where any group of 100 or more registered voters who have an interest in the rule or feel that they are affected by the rule can file an application for the legislature to review that rule with the executive director of the Legislative Council, Suzanne Gresser. And you can see in the law there that the application states the rule that they're interested in, how they feel that the rule has adversely affected them, why they think the rule is inappropriate or unnecessary, and a recommendation for a change to the rule. So I'm in my own way here for moving over the statute. So hopefully you can see that. Can you tell that I've moved to the next section of law? Okay, good. I'm never quite sure what works when I'm sharing the screen. So I know that you've seen this section because it was included in the materials that that Erin forwarded you from Suzanne. So this is the petition piece for you. So the executive director sends the petition to this committee along with the rule application. And this is the key part that I want you to understand, that each committee member individually reviews the application. So this is not a vote of the committee as a committee in the way that we normally would work. So your job, and I'll bring up the ballot in a minute, so I know you have it, but just so you can see what it looks like again, your job is to determine whether you think that the applicant is qualified and whether the public interest would be served by a review of the rule by the full committee. And if you decide as a member individually that you think a review should be made, then you have to notify the director within 15 days. I believe that's the 29th, but I'll bring that up in a minute as well. And the process is if a third or more of the committee, so that's 5 members, believe that or put in their ballot that they believe there should be a review, then the director will let the chairs know the outcome of that vote. And if there is a 1/3 vote to review, then the committee must complete that review within 90 days of notification to committee. So if that were to go forward, then there would be a meeting to review the rule. That meeting would obviously be public, but it would be scheduled by the committee chairs, and the agenda would also be set. And you can see right there that it says that the committee in the course of its review may hold a public hearing, request and obtain opinions of the Attorney General, obtain information from the agency, and conduct further investigation approved by the Legislative Council. And then you can see the 90 days there. And then the next section of law, if there were to be a review, then the committee would consider whether the rule is consistent with the statute, whether the effects of the rules are reasonable, whether the circumstances have changed since the passage of the statute which the rule implements, and whether the rule may tend to promote an abuse of discretionary powers of the agency. And you could ignore F because that is not an issue here. And then if the committee does determine that any of the criteria for the review have not been met, you can have discussions with the agency. You're also allowed to report out a bill, and you can see right there that only by a majority vote of the committee shall legislation be introduced to amend or enact legislation pursuant to this section. So for example, if you were going to write a statute that directed an agency to do something different with their rule, you would need a majority vote to do that. So I'm going to stop sharing there only because I need to share something different, and I haven't quite figured out how to go from one place to another. This is the memo that you received, and you can see here that Suzanne has put in that same language from the statute that each committee member individually reviews the application and the supporting materials. But I just want to point out here that you have this no later than May 29th date. So that's the deadline. I realize it's 15 days. I believe we got it on Friday, but we did want to have a little explanation about it before you received the ballot yesterday, but we did want to have an explanation because this doesn't happen terribly often. We had one about 4 years ago that was related to childcare, and we had a couple of years before that as well. And one was related to Section 21 and another was to Section 17. But it didn't used to happen at all. And now it seems to be something that happens a little more often. And then this is the ballot that you have, and you can see here that you check one of these. This is the qualification. This would serve the public interest, and then your name and signature and date. And that needs to go to Suzanne Gresser. If there's anything we can do to help you with that, we're happy to help you with that. But this is something that it does go directly to Suzanne. In before times, we would, have sometimes collected them up from folks and taken them over, but we're not in the cross office building. So I would suggest that it's probably most straightforward for you to do that by email or directly contact Suzanne. And Suzanne's email is on the email that Erin forwarded to you yesterday with the ballot, with the law, with the rule, with the petition. And if you can't find it, we're happy to send it to you again. But we just wanted to let you know that you have until May 29th to put in your ballot to Suzanne if you believe that this rule should be reviewed. I'm not going to talk any specifics about the rule or any of the content. We'll do that if there's a review. We just wanted to explain the process to you under the APA and what it means for you at this stage. But if you have any questions, let either of us know. Either of us can answer these questions. And if you have others that you want to talk to Suzanne about, you're also welcome to do that as well.
Everybody all set for right now? It's just it's a heads up, a 101, and there'll be opportunity to discuss down the road. Okay. Anything else we need to attend to before we get to consideration of bills?
I have things at the end, but not at the beginning.
Okay. Amendments, right? Or language?
I don't have language. I have a couple of, I have, well, it would be easier to explain them at the end.
Okay. All right. All right. So let's begin with LD 1458 from Representative Talbot Ross, and see where that takes us.
$14.58 or $15.48?
What did I say? I meant to say 1548.
Thank
the
you.
first on the list.
So this bill is an act to alleviate the disproportionate impact of COVID-19 and public health outcomes. The bill, as drafted as emergency legislation, it requires that at least 10% of the discretionary funds that are not otherwise earmarked received by the state from the federal government due to the pandemic be used to address the needs of historically marginalized racial communities in the state. Directs the department to consult with and accept recommendations from the Permanent Commission to ensure those funds are used to address those needs, and requires the department to submit a report until the funds have been used or obligated. At the public hearing, the sponsor proposed an amendment that would remove the emergency preamble and clause, direct the department and the Permanent Commission to determine the appropriate levels of funding in need, and to specifically answer the following questions: the amount of federal COVID relief funding received by the state directed towards public health and healthcare, the amount of funding intended to address racial health disparities, the amount of funding that has already been directed to these communities and outcomes from this funding, and the identification of existing programs not related to COVID funding designed to target racial health disparities. And the sponsor's amendment indicated that tribal populations as a group would not be included in this discussion. It would be because of other existing funding streams, her amendment said. And it also requires the department to report back to this committee by January with its findings. I had some questions about the bill as originally drafted, about whether the things that I had highlighted were sufficiently clear. And I think that since I drafted this amendment, I've clarified that the proposed amendment by the sponsor is a strike and replace of the original bill, as opposed to an addition to the original bill. So I don't have those same questions anymore, if that is indeed the intent, to strike and replace it. I provided you with some of the cross references in statute and the original bill that doesn't exist in the proposed amendment, and the statute authorizing the permanent commission. You do not yet have a fiscal impact statement.
Any questions from the committee related to that analysis from Aaron? Thank you. I'm not seeing any. Yes, Representative Perry.
Well, the question I have is on the amendment in terms of striking Indigenous people. And the question is, we have federal funds that come in that actually require that the Indigenous people be included. So I hesitate to leave that in. I mean, would it be possible just to leave out that statement, making the exception of the Indigenous people being able to be a part of this discussion?
We can do what we want as a committee with the bill. Representative Meyer?
Thank you, Mr. Chair. I share Representative Perry's concern about excluding the tribal populations, and have spoken with the bill's sponsor, who is feeling under the weather this morning and unable to join us, who's indicated to me that we can include the tribal populations back in.
Does that answer your question, Representative Perry? Yeah, we'll address that concern. Representative Craven?
Yes, thank you, Mr. Chair. And I'd be very happy with that amendment as well, and support striking that.
So question to Aaron, is that language in the proposed amendment now such that it has to be struck, or is that
Her proposed amendment isn't really drafted the way we would draft amendments. I think it was by way of explanation, explaining what the scope was that she wanted.
So at this point, we can just leave that out. It's because it's not in, or just not put it. Yeah. Okay. All right. So no major language changes. It really requires adoption of the motion. Senator Moore.
Thank you, Senator Claxton. I'm just wondering if we have anyone from the department that is maybe in the attendees room. Just a question on, I guess, what are the plans on handling the discretionary funds, and how are they going to fairly distribute them so that we make sure everyone, not just the historically marginalized racial communities, but every community or every situation is covered? So I just wondered if we had anybody from the department who could actually respond to that question.
We've been joined by Molly Bogart. Welcome.
Good morning. Thanks. I'm Molly Bogart, Director of Government Relations for DHHS, and I missed a bit of that question through the wormhole, but I think I got it. You were asking what the plans are for the discretionary funding, and the governor did release her. The title is escaping me only because there are too many plan titles in my head at the moment, but basically her plan for the discretionary funds, of course, that is subject to legislative approval. And, there is some funding that has gone in the between the supplemental and the ARPA funding to fund the permanent commission, as well as address some of the health disparities within programs that we have, or through programs that we have here at CDC. I apologize, I would need to get you more detail there, but that plan is where that information would be.
So it sounds like it's evolving. Is that enough information, Senator Moore? Do you have additional questions?
No, that's enough information. I get concerned when we start by law and statute saying, okay, you must give 10% here and you must do this and you must do that. When it's an evolving plan or it's a working document, I guess, working plan document. That's just my comment.
Sure, and that 10%, as I understand it, has been struck in the amendment. Now it's a conversation about how to do it and what the numbers ought to be, as opposed to stipulating a specific solution in the amendment. I was uncomfortable with that too. Okay. Any other comments or questions related to LD 1548? Representative Meyer.
Thank you, Mr. Chair. I think as well, if we're moving in this direction, that we need the Perry Amendment or a report back to our committee.
Now infamous, Representative Perry. In addition to fabulous. So we'll entertain that as a motion. So Representative Craven.
Well, I was just going to, thank you, Mr. Chair. I was just going to make a motion on a pass as amended.
And thank you for that. Is there a second?
Second.
Thank you. Any further discussion of LD 1548 in the amended version, which is to include a report back and the opportunity to write legislation in response to what we learned? Not seeing any. I will defer to Ms. Withy for tabulating the vote.
Representative Zager,
Yes.
Representative Zager, yes. Representative Lemlin,
No.
Representative Lemlin, no. Representative Stover,
Yes.
Representative Stover, yes. Senator Baldacci,
Yes.
Senator Baldacci, yes. Representative Perry,
Yes.
Representative Perry, yes. Representative Griffin, Representative Griffin is absent. Representative Connor, Representative Connor is absent. Representative Craven,
Yes.
Representative Craven, yes. Representative Madigan,
Yes.
Representative Madigan, yes. Representative Javner, Representative Javner is absent. Senator Moore,
No.
Senator Moore, no. Representative Meyer,
Yes.
Representative Meyer, yes. Senator Claxton,
Yes.
Senator Claxton, yes. That's 8 yes, 2 no, 3 absent.
Okay. So then we can go to consideration of, is there a minority report?
It would be ought not to pass.
Okay. All right. And next we can go to consideration of LD 1392. That would need to come off the table first because this is a repeat work session. Representative Craven?
Yes, I move that we remove it from the table.
Motion and second. Representative Zager, thank you. So we can do a show of hands. All those in favor of removing it from the table for further consideration of LD 1392. That's unanimous of those present. Okay. So as we left 1392, we were waiting for some more stakeholder work to happen. My understanding is that that has happened. Molly's here. Is there somebody else who wants to testify about LD 1392? Or offer thoughts about 1392? Molly, do you have something that you want to contribute?
Sure, and I don't know if the sponsor's here and she could certainly speak to it, but There were a handful of stakeholders that did meet. I was with you, and so I wasn't there, but I did get a readout of the conversation, and it sounds as though we have comfort from DHHS, Department of Public Safety, and MHDO to have the committee sort of list the information that you would like to receive in this report. And then we will go and do the work to figure out how we get it to you. Putting any more detail into a statute, I think, would only complicate that data collection process. And so we're happy to go and do that work in the interim and provide the report to you next year. I believe the group was also interested in having this be a report, a standalone report, rather than as drafted within the director's annual report. So that is, certainly something that we would be comfortable with and up to the committee, but I believe that is where we landed.
Okay, thank you for that update. And the language that we're currently considering actually is the amended version. Is that something you want to put up on the screen for us, Erin?
Yes, I think so. Hold on.
So this is the amendment. There's some language changes that are highlighted in red and some language eliminations that are highlighted in red also. Any questions about this page? And some of there's some struck language in item 4, and there's some added language in D that adds Office of Chief Medical Examiner, Office of Maine Attorney General, and the Maine Health Data Organization. And also a category for, sorry, I can't read that, unintentional and intentional. Okay. I see some hands up. Representative Zager?
Thank you, Mr. Chair. I know the sponsor is not presently available, but Mr. Bickford, who,
she is here.
Forgive me.
Welcome, Representative Gramlich. I knew you were coming.
Thank you very much. And I think Representative Zager was going to mention that Jeff Bickford is also in the waiting room, who's done an enormous amount of work with me on this amendment and this bill. Generally speaking, he's in the waiting room if the committee has any questions for him as well.
So at this point, the only amendment that's been, in addition to the language that's been presented, the only other, and I can't remember whether the standalone report is included in your amendment or not.
It was not, Senator. When we put together the language, we had then gotten information from Molly Bogart that it was a recommended component that did not get included in the final iteration of the amendment.
Okay.
I would love for the committee to consider that. I think it's a great idea and the department supports it.
Mm-hmm. Mm-hmm. Okay. Representative Meyer.
Thank you, Mr. Chair. I would agree that a standalone submission to this committee, as opposed to the CDC Director's annual report, should be included in the amended language.
Okay. Any other thoughts about that particular amendment? Okay. Any other questions or concerns? Issues related to this bill that people want to surface now? I'm not seeing any hands up. Does that mean we're ready to vote? Looks like it. Yes, Representative Craven.
Thank you, Mr. Chair. I move to pass as amended.
Second.
with the amendment being the standalone report at the end with the opportunity to write legislation if we learned anything that would be helpful. And actually not to write legislation because that report's supposed to go to criminal justice. So that would be additional in terms of where it goes. Any other comments? So we have a motion on the floor ought to pass as amended. It's been moved and seconded. Any other discussion? Not seeing any, we'll go to Ms. Withy for the vote.
Representative Zager,
Yes.
Representative Zager, yes. Representative Lumlin,
No.
Representative Lumlin, no. Representative Stover,
Yes.
Representative Stover, yes. Senator Baldacci,
Yes.
Senator Baldacci, yes. Representative Perry,
Yes.
Representative Perry, yes. Representative Griffin, Representative Griffin is absent. Representative Connor, Representative Connor is absent. Representative Craven,
Yes.
Representative Craven, yes. Representative Madigan,
Yes.
Representative Madigan, yes. Representative Javner, Representative Javner is absent. Senator Moore,
No.
Senator Moore, no. Representative Meyer,
Yes.
Representative Meyer, yes. Senator Claxton,
Yes.
Senator Claxton, yes. That's 8 yes, 2 no, 3 absent.
Thank you.
And the
Minority
minority
report?
report would be that ought not to pass.
Very good.
Can I just clarify, this is the report from the CDC, you want it to go to criminal justice, or do you want it to come to this committee?
Well, we can hear it. The report should also go to criminal justice. Maybe I'm mixing metaphors here.
I think you are, Mr. Chair.
Yeah, I'm sorry. I'm sorry. Yes,
There was
But-
an
Right.
upcoming bill that
Right.
will work
Thank you.
today. Yeah.
right. I was so busy trying to collect the minority report that I got messed up. I don't want to get called out by Senator Moore today. All right, thank you. So before we go to consideration LD 949, I'll check in with Senator Baldacci. We were awaiting an amendment. I assume that hasn't come yet. You're on mute, sir.
Thank you. I am just about to send it to you. It's been finalized with the nursing home people and the Senate President's office, and I can send it to you. And if we could go on to another bill and then come back to this, I want to circulate.
Okay.
it to
That's-
the
no,
members
that's
of the
fine.
committee
No,
first.
that's fine.
Okay.
And
It will go out in
Representative-
about 2 minutes to everybody.
okay, Representative Connor has rejoined us. Do you want to cast your vote now? Your votes, Representative Connor, or you want to do that at the end after you're done jumping back and forth?
I'll probably end up doing it at the end of jumping back and forth all day today,
Okay.
if you don't mind, Mr.
Okay.
Chair.
It's hard to be two places at once. Okay, so we'll skip 949 for right now and go to 1608.
All right, 1608. This is an act to expand the main care program to cover all citizens of the state. This bill establishes a single payer healthcare system in the state that provides healthcare services to Maine residents. The bill directs the Department of Health and Human Services to consult with the Department of Labor and the Department of Professional and Financial Regulation, Bureau of Insurance, to design the program to provide coverage for healthcare services from participating providers within the state if those services are necessary or appropriate for the prevention, diagnosis, treatment, or rehabilitation after injury, disability, or disease. And it also establishes minimum services in the statute. The bill requires the state to implement the program in 4 phases based on income, beginning in 2023 for those residents not already eligible for the main care program. The first phase is convening a committee for an RFP, a study of the cost, benefits, and issues and any federal waivers. and any waivers must be applied for by June 30th, 2023. And then the first phase is those individuals that are less than 200% of the federal poverty level and not eligible for main care. The second phase is 200 to 400% of the federal poverty level. And the third phase is greater than 400%. The bill also creates the Main Care for All implementation task force. I'm sorry, I'll try that again. Main Care for All implementation task force. I won't be reading audiobooks anytime soon. To advise the departments and make recommendations to fully implement the single payer healthcare program. The task force is made up of 10 legislators and is staffed by the Legislative Council and includes consultants representing hospitals, providers, consumers, and small and large employers. And the program may not be implemented in 2023 without prior legislative approval. I don't have a lot of additional information. I did just want to draw your attention to LD 1045, an act to support universal healthcare. Representative Brooks sponsored that bill, and I believe HCIFS has a work session for that bill today. I'm sure Representative Connor knows much more about it than I do. And you also received some information from other states that was forwarded from Representative Harford and Sylvester, which I can bring up on the screen if you'd like, but you did receive that separately, and all I did was forward it. So that is all I have for you on this bill.
Does that prompt any input from the committee? Any questions, concerns, feedback? I'm not seeing any, so I do see that we're joined by the sponsor. Any questions from you, sir, about that analysis?
No, Senator, thank you for having me on. I just want to say that I think, thank you for the hearing. I thank you for the time and attention that you gave it. And this bill is part of a movement. You received information about a federal bill, which would allow states to automatically get the waivers to institute such a program. And so that's sponsored by Senator Rokana or Representative Rokana. And so, I feel like it's the time that Maine should stop and consider whether such a program is feasible and answer that question. And I appreciate all the work that the committee has done considering this bill.
Okay. So as I understand it, a companion, or probably better term, a related bill is being considered in HCIFS today that deals with private insurance. And they're looking for a way forward too to move things along, or considering a way to move things along. Yes.
Yes.
Representative Sylvester?
Yes. And so I think that these bills were both brought in the 129th. And at that time, the study, it was combined into one to create two separate task forces to look at whether a single payer system could move forward, or whether there was some other tweak of the ACA or other universal care programs that would move forward. I think that the main difference between the two bills is the Representative Brooks' bill is creating an entirely new system of insurance from scratch, and where this bill is using Maine Care as the vehicle. And so, those are I think they are in that way two very separate bills, and envision a very different process for achieving the same end.
And both would be dependent, as I understand it, on getting federal blessing or waiver to adequately capture all the various revenue streams that would be necessary to support this initiative. Is that a fair statement?
It is a fair statement. I think that the difference is that the waiver that we would be seeking is to allow people to buy into Maine Care. The Maine Care funds that we receive that are instituted right now would be used in a very similar fashion to how they're used for those at the lowest economic end. What this would allow is for us to raise taxes to essentially be able to allow people to buy into the program, to use the infrastructure, to use the processes and rules we already have in place, the reimbursement procedures, so that we are not reinventing a system from scratch. That should produce considerable savings, and that's what this committee will be looking at.
This committee being the task force work group that's
Yes.
that's built into the right. Okay. I want to
Yes.
make sure which
Yeah.
committee was doing that work, but
Sorry. Yes, it's not you, Senator Claxton, I promise.
it's not us, right? Okay. All right, any other questions or comments of the sponsor? Yes, Representative Connor.
Thank you, Mr. Chair. Representative Sylvester, raising the taxes on who and by how much?
Thank you for the question. So it's employers, for example, who wanted to buy into the program because they saw that there would be a savings from either the market, traditional independent or private insurance, or to the ACA plans that are available would be able to buy into it. And so that would be levied, whether it's called a tax or whether it's called a premium. It's the same basic idea. Employers would be able to pay for insurance, or individuals would be able to pay for insurance at what we would consider would be quite a savings from what all the numbers show us right now for a state of our size. And so that's what the commission would be looking at exactly. And the reason I don't prescribe it is, as I said in my testimony, I like to get the smartest people in the room, and have them try to figure out what the best way to move forward on policy is, rather than trying to prescribe it in the bill and in the statute, right? Let people do the work that they know how to do. And so that's what they would be looking at. And whether you call it a tax or a premium or whatever you wanted to call it, there would be the ability for people to take the money that they're using right now in private insurance and use it to be in this system. And that's the goal.
I think I was just using your words. You just stated that we are looking to raise taxes. So I just wanted to respond to that. And I appreciate you answering the question. Thank you. That's all I have, Mr. Chair.
Of
Thank
course.
you. And can you speak, Representative Sylvester, to what the current overhead is, the administrative cost is of main care versus the private insurance market?
So I think that one of the pieces when you look at private insurance is the overhead of the infrastructure. Some studies have that as much as 1/3 of the total cost of private insurance. And so that presumably would be reduced right off the top from using the main care infrastructure, understanding that there would need to be new hiring in order to aid that system to process what would be a larger group of people. But there would be, initially there would be advertising, there would be all those things, but eventually sort of the competition that happens within the private healthcare market in order to put your product out there would no longer be paid. Now, the biggest piece that we see in savings between using a main care for all program and using private insurance is catastrophic care, and the need for private insurance to pay for the margin between what main care covers and what the cost of care is, as well as the cost of indigent care, which, as you're well aware, hospitals are required to provide. And so those two things would provide a second layer of savings between the two systems. And then finally, the ability of main care to pay in a timely fashion puts particularly our rural hospitals who provide care and can often wait up to 2 years to get paid for the care that they provided. They would be paid in a fashion that would, the bill envisions would be $1 for $1 rather than 70 cents on a dollar. Private insurance wouldn't be, taxed up to 170% to make up that difference. And we would be able to have that third layer of savings. So ultimately, all of the preliminary work that have been done in other states and that have looked at smaller states doing this, and I think that that's an important piece of this, is that the folks that I worked with putting together this bill see that a large state like California could do this because of their massive resources, and a smaller state with a good main care or a good Medicare plan like Maine could do it because of the reasonable number of people within the state. So that's what that's what this task force will be looking at, and and that's what they will ultimately recommend for an implementation system.
Thank you. Are there additional questions? Yes, and I'm not seeing any. Senator Moore.
I really don't have a question for Representative Sylvester. I just had a comment. In reading back over the department's letter that was sent to us dated May the 11th, I'm really reminded that I don't know that we really need this bill because the administration has been working quite hard to get affordable health coverage, care coverage throughout the state of Maine. We've got the Maine Care expansion that we've been working on. Additionally, the department has launched the multimedia campaign through Cover Me. There's conversations about having our own state-based marketplace set to open this fall. I think there's a lot of work in progress to get to that goal where we're going to have coverage across the state. So I really do not think that this bill is necessary, in my opinion.
Thank you for that comment. Did you have, did you want to say something, Representative Sylvester, as long as you don't get into a debate?
Oh, I would never do that as a non-member of the committee. I just wanted to say that the reason I think this bill is important is that, the hundreds of people that I hear from as the chair of labor, and I'm not even in the jurisdiction of healthcare, who call me about their health insurance plans, failing their employees, having catastrophic care that they're unable to use. I just think that we need to take a good look and try to implement a system that we know works well and that will cover all Maine people and that will do it at a significant savings.
Thank you. Any other questions or comments? And are we ready? Representative Perry.
I have a question, and I don't know if somewhere back in history, I believe, this is my history too, but
okay.
There was a period of time where there was a program where Maine Care offered buy-in to Maine Care, and I would like to learn more about that. I'm also thinking maybe some study on how that would work might be worth doing to move forward, at least for those people who are missed both by Maine Care and by the ability to afford the exchange on this piece of it, and to see what happened to that program and why it doesn't exist anymore.
So that's additional information you're looking for. Representative Sylvester?
I do not have any information on a historic program that did that. I'd be happy to try to look for it, or it would probably be exactly the type of thing that the task force would be looking at, is the history of the program and all waivers and other pieces that had been historically passed.
I believe that was the, sorry.
I interrupted somebody. Who did I interrupt? Yes, Senator Moore.
I was just going to say, I believe it was the Derigo program or the Derigo plan that they were able to buy into.
Okay.
And I can't remember the history of why it was discontinued. I don't know, maybe Molly might have that information, or someone from the department might. But I know that there was reasoning behind its discontinuation.
You're talking about the ability to buy into Maine Care. Okay.
Okay. Representative Lemlin.
Yes, thank you. Like I mentioned earlier, we had the Affordable Care Act start in 2010, and every single person on the left thought that this was going to be the greatest thing ever. And of course, like predicted, it was a complete failure. Copays before the Affordable Care Act, copays were $10. Deductibles were around $500, $250 and $500. And insurance was affordable. My insurance for my family owning a private business, and private business owners, their insurance are the highest, was $385 a month. A year and a half after the Affordable Care Act, my insurance went from $385 to $800 a month, And then 6 months later, the company just said, we can't afford this anymore. We're not going to insure you or anybody else in Maine. And it was gone. And all of a sudden, I had no insurance. This happened to thousands of Mainers. 90% of the problems that we're having right now are because of the Affordable Care Act. And now what I'm hearing is you want to extend this further and try a new little loop, and which is this bill, Maine Care for All. I'll give you a little hint. It is going to be more devastating on Maine than the Affordable Care Act was. This is not the solution. This is going to fall apart. And if you don't believe me, just take a look at what happened with the Affordable Care Act. Now, I heard the representatives and senators tell me that the reason it failed was because insurance companies got greedy. Well, if you think insurance companies got greedy, you wait till the state of Maine handles this. First of all, I don't know of anybody in the state of Maine or in the system that has the capability of handling Maine Care for All. So that's going to take years and years and years before you have anybody within the department that could deal with this. Number two, the copays, I think it was the representative here that said copays and deductibles were sky high, and that's why the Affordable Care Act failed. That's not true. The Affordable Care Act caused copays and deductibles to skyrocket. And I'm not going to go into the whole details, but if anybody wants to sit down with me, I have absolute documented proof as to why the Affordable Care Act caused deductibles and copays, because I looked into it with insurance companies because I owned a healthcare facility. So anyway, that's all I have to say. I'm against this bill 1,000% because I know it's just a failure, but thank you.
Thank you. Any other comments, questions, concerns? All right. Representative Sylvester.
Thank you. I just wanted to take this moment to say I apologize for standing in my yard, and I was working at my small business. I made it that close to a clean shirt and my Zoom room, but the bill came up early. So I just want to appreciate all of the conversation today and all of the questions, and thank you for taking the time on.
Thank you for being here. Any other comments, questions? Yes, Representative Lemelin.
Yeah, I want the representative to know that his intent, I'm all for. I'm 1,000% in favor of getting health care to everyone in Maine. So it's not his intent that I'm against. I'm 100% for it. I think he has a great idea to try to help people. The problem is how we accomplish that goal. I'm afraid that we're just heading down the wrong path for that. Thank you.
Thank you. All right. Then, yes, Representative Perry. When you're off mute, we want to hear what you have to say.
Oh, darn. You mean you have to hear it? I think there is much that we need to do. The increased cost of insurance is not just because of the Affordable Care Act. It's also because of the increases in healthcare itself, which goes far beyond what we call cost of living. And that's been happening for years. One of the things that is being proposed and coming forward in the Health Coverage and Insurance and Financial Services Committee are two bills. One is Senator Jackson's bill 120 that proposes to create an OPEGA-like legislative committee to actually look at healthcare in general. The other bill is one I put forward that really proposes also to take a systems look at healthcare to see where we can be more efficient and better at containing also the costs of healthcare. Because many of the reasons insurance increases is because of the cost of healthcare. They're paying for it as well as the rest of us. And so I would like to see if this bill passes, quite honestly, or a combination of it, because we need to be doing a much more constructive and constant look at our systems of healthcare to see what we can be doing, not only coverage, because coverage is only one small piece of it. It isn't going to take care of the whole issue. And I'm wondering if we can fit some of this or maybe hold on to this to see if this bill passes and see if we can give some of that direction to that committee if that comes through. Just a thought.
So you're raising the possibility of tabling it for now and then waiting for HCIFS to get done with their review of those two bills.
Yes.
Okay. Any thoughts about that? Did you want to make that? Yes, Representative Craven.
Yes, I would make a motion to table.
I'll second.
So the motion to table has been made and seconded. All those in favor of tabling, please put your hand up, and that would be unanimous of those present. So we'll table it for now. We'll get it on the calendar down the road when we have a better time frame from the folks at HCFS. I guess they're in work session today, Representative Connor, about these bills.
We are in a work session on Representative Brooks' bill today. Yes, we're.
Okay. Okay. Very good. So that has been tabled for now. That would take us to LD.
Mr. Chair,
Yes.
just a quick question for Representative Perry on the status of her bill. What is the status of the bill you referenced? You're on mute, Ann.
I keep trying. They have not been worked yet.
Okay.
And I don't know when they're scheduled to be worked. I haven't seen a schedule on that yet. But I know I talked with the chairs and they're going to work both those bills together.
Okay, great. Thank you.
Representative Perry, what is the number of your bill?
I'll get back to you in a moment.
Thank you.
All right. So now I guess we'll go to 1695. Thank you for being here, Representative Sylvester.
Okay, hopefully you are looking at 1695.
We are.
Okay, good. This is an act to improve housing security by improving access to general assistance. This bill makes the following changes to the Municipal General Assistance Program. It provides that a person receiving housing assistance that meets or exceeds the maximum level in a municipal ordinance is eligible for assistance for other basic necessities. It extends presumed eligibility for general assistance for a person who is experiencing or facing homelessness, but is unable to be housed in an emergency shelter because the shelter is full or because the municipality does not operate a shelter. It requires the department to reimburse municipalities and Indian tribes for 100% of the cost of providing emergency shelter to a person eligible for general assistance living in a homeless shelter. And if the municipality does not reimburse the emergency shelter for general assistance costs, the department is required to reimburse the shelter directly. It requires the Department of Health and Human Services to reimburse municipalities and Indian tribes for 90% of the direct costs of providing rental assistance. It requires a person who is receiving rental assistance under the General Assistance Program for more than 30 days to be prioritized for housing vouchers administered by Maine Housing, and rules to implement that requirement are routine technical. It transfers unspent funds, state funds, for general assistance to the department to be split equally for rental voucher programs administered by the Office of Behavioral Health, House Navigation Services for General Assistance, and the Office of Behavioral Health, and to the Maine State Housing Authority for the Housing Opportunities for Maine program. And it amends the Maine State Housing Authority Housing Opportunities for Maine program to allow that funding to be used for navigation services to assist with locating rental housing, negotiating leases, and providing services to establish good landlord-tenant relationships. You heard a number of issues from the testimony. One of the big ones was that housing costs are using the maximum amount of assistance, and there is nothing left for other necessities. And not all communities have shelters, so the sponsor is looking for presumed eligibility in communities without shelters, and was looking for 90% reimbursement for rental assistance rather than the maximum of 70% in current law, which is the 70% that applies to all general assistance costs. And if getting rental assistance, there should be a prioritization for housing assistance. And you heard about the unspent general assistance funds. And I don't know where the statistic comes from, but you did hear it a number of times that 80% of general assistance goes to housing. You heard from the proponents that presumed eligibility during the pandemic has worked well. That's on the executive order. And you also heard a request for general assistance to be administered uniformly at the municipal level. You heard from MMA and the City of Bangor, neither a for nor against. That's because there are some pieces they're opposed to and some that they are not opposed to. Providing GA over the maximums and additional presumed eligibility will increase costs to states and to municipalities. They would no longer have statutory maximums, and that would also require additional administration. And they are seeing clients that have vouchers who still can't find housing, and they also believe that it changes the intent of resource of last resort. Maine Housing is opposed to the housing provision in Section 6. This is the priorities for housing vouchers. Maine Housing said that there are already priorities that exist in federal law, for example, veterans. There are no state housing vouchers. There are some OBH ones, but that's different. And they also mentioned that there are 23 other local housing authorities, but only Maine State Housing Authority is cited in the bill. And they argue that no one in the Section 8, that's the federal Section 8, not Section 8 of the bill, nobody in the federal Section 8 voucher queue for, there's no one in that queue for which a priority argument cannot be made. And they were also concerned about Maine Housing being in Title 22 rather than in 30A where their authority is located in the statute. The department, housing maximums are based on HUD calculations to reflect local expenses. There are other maximums in general assistance that are examined annually and approved by the Maine Municipal Association, the Welfare Directors Association, and the department. And homelessness is already considered an emergency in GA law, which is slightly different from presumed eligibility, but that was the bill from a couple of years ago that was sponsored by Senator Chipman that would allow for homelessness for emergency in GA law, which is how you get the housing in hotels and so on. And the department also said that they may need to hire additional staff for housing navigators. And I didn't mention, I guess I forgot to put it in, but the department is opposed to the bill. There is some inconsistent terminology here around housing costs, rental assistance, and shelter that I find a little bit confusing when I read. I mean, some of it's because the law is confusing, but Section 2 of the bill refers to housing costs. The definition of basic necessities that already exist in law refers to shelter costs, shelter more broadly, not shelters as in homeless shelters, but shelter more broadly. And then Section 6 of the bill states that a person is determined eligible for rental assistance should be prioritized. So I just think it's worth cleaning up some of that and if you wanted to move forward. Section 6 of the bill requires unspent funds to be transferred equally between the Office of Behavioural Health, clients needing transitional housing to increase vouchers. I assume that means BRAT, but I don't know that. That's why that question mark is there. Navigation services and Maine State Housing for the Housing Opportunities for Maine program. Just as a note, the Office of Behavioural Health isn't in statute. None of the offices in DHHS are named in statute specifically. The navigation services are unclear. I don't know who does what exactly in terms of navigation, and also how much of a general assistance is rental assistance. The reason I ask that question is because the existing law has 70% reimbursement level to municipalities from the state for general assistance, and that section is being is notwithstanding. So I don't know if that 70% reimbursement level even really makes sense if most of general assistance is going to rental housing, to shelter housing. Now I'm going to trip over all the different terms myself. And if that is at 90% or 100% for homeless shelters, that gets a little muddy to me. Actually, I want to go back up here because I missed one that I realized as I was going through what the bill does. That is also a little bit confusing, is this section right here, this number 3, where it requires the department to reimburse municipalities for 100% of providing emergency shelter. And if the municipality does not reimburse the emergency shelter for general assistance costs, the department, I don't know what that means. That needs some clarification as well. You don't usually see a requirement for an entity to do something and then say in law and then say, but if that doesn't happen, then this happens. I mean, if it's a requirement in law or it's not. So additional information, I don't have a lot, except I did want to draw your attention to the issue of the unspent funding. Molly did send an email with all of the municipal funding, which I can bring up if you like, but you have that separately. But also on this issue of unspent funding, Molly said it's important to note that the 12 million is no longer correct because of the executive orders deeming every application or case an emergency through the pandemic. That allows additional expenditure and increased utilization, and much of that funding has been spent down. You did receive the executive orders relate to the emergency. And then just as a reminder of Public Law Chapter 2019, Chapter 515, which I mentioned already, which added homelessness into the emergency section, said that a homeless person could receive emergency general assistance, and then added the presumptive eligibility for the person who has provided shelter at a homeless shelter. I realize it's a little bit of an odd distinction, and I realize the sponsor is trying to kind of make that mesh a little bit better. So a homeless person in a community or at risk of homelessness in a community that doesn't have homeless shelter is still eligible for emergency general assistance, and this is completely unrelated to the executive order. But the presumptive eligibility does only apply to the person at the homeless shelter. And then I don't need to read the rest. I just wanted you to see the notwithstanding sections of statute, and that's because Erin and I have no longer been posting existing law because we just ran out of time. So we haven't been posting that on the website. So that's why all of this is at the bottom here. And then there's something else I wanted to show you. This is just the 4311 section I was telling you about with the 70% reimbursement of notwithstanding. And then I just wanted to show you the existing law for the Housing Opportunities for Maine program, because this is where the navigators are going in. And so that's a section of law that you also would not have been seeing. And we haven't yet received a preliminary fiscal impact statement from OFPR. I'm sorry, that was a lot of yakking.
Before we get into consideration further, we've been joined by the sponsor and ask if she has some additional thoughts to share with us.
Thank you, Senator. Yes, I do. And I do appreciate the analyst's analysis. And I agree. The statutory schemes are so very confusing, and it's challenging for folks to navigate them. My intent with this bill, and as you can see, I've submitted an amendment, and I'd like to offer this to you all, which really synthesizes the bill down to the core, which is about accessing these very important services. And so what the bill that I'll submit to you today for your consideration includes only sections 2 and section 3 of the bill, which regards the maximums and which regards the presumptive eligibility. Everything else I'm taking out of this bill for your consideration today.
That pares it down significantly. So thank you for that, given where we are in our cycle, and appreciate your efforts to try and get to what's truly at the heart of legislation. So that's important. So that will refer to sections 1 and 2 on the analysis portion, but sections 2 and 3 of the bill, just to make sure we're all talking about the same thing. Unless there are any confusion, any questions, either for Representative Morales as the sponsor or for Anna after the analysis. I'm not seeing any. So that appreciably changed the bill. Does that impact how folks look at it? Are we ready to vote? Are we ready for a motion? Yes, Representative Craven.
Thank you, Mr. Chair. It certainly, simplifies the bill for me and can understand it better. And I would make the motion ought to pass as amended.
And Senator Moore, you had a hand up.
Well, you have a motion going right at the moment. I'm not prepared to vote on this until I actually see the amendment. I don't feel comfortable doing that. So I
Okay.
just want to make that statement.
All right. Is somebody going to second the motion just to complete that portion? Motion's been made and seconded. Did you have a hand up to Representative Zager?
Just to second the motion, Mr. Chair.
Okay. So to address Senator Moore's concern, Anna, do you have the original bill that you can put up?
I'm working on it. Just give me 1 second here.
No, that's okay.
Senator and Anna, I did send the amended version to Aaron. And Anna, I don't think I included you on that, so I don't know if you've received that, but I could send that again.
I have it now. I'm just going to bring up the actual bill though for Senator Moore because you're just keeping 2 sections, so it's easier just to look at the bill. So hang on 1 minute, Senator. I just have to find the right screen. All right. So if you look at this, Senator Moore, it's literally 2 and 3. That's what she is looking for now.
And none of the language in section 2 and none of the language in section 3 are being proposed for change. Everything else is to be struck. Do I have that right, Representative Morales?
That is correct.
It's getting bigger, Senator Moore. Thank you, Anna.
I saw you peering at it, Senator Moore, and I was like, oh, right, I can make it bigger. I can even make it more bigger. There you go. It gets a bit blurry when you make it bigger.
Well, I guess the question that if we're looking at section 3 with the presumptive eligibility, again, has the section in there. Let me see, wait a second. Okay, never mind. That's not the part that we've said, the confusion part about who has to pay for it if they don't.
No, that's correct.
That is not it. Okay.
That's not part of that any longer. As long as this is up, does anybody else have any questions related to that? Thank you for putting that up, Anna. I'm not seeing any other questions. I do see that Honorable Eric Jorgensen has joined us, so I'd invite him to unmute and see if he's got any input that might help us with this. Any other thoughts, Mr. Jorgensen?
Yeah, sorry. There.
There we
Yeah, I think actually we are, the objections that we lodged initially were entirely based on the housing part of it and the prioritization issue. So by eliminating the subsequent parts of the bill from after 2 and 3, I think it really removes all the housing stuff and really focuses this on general assistance. So I think any objections we had are certainly at this point null and void.
Thank you for that contribution. I also see that there's a hand up And I will, if I can find her, bring in Kate Dufour. Can you do that, Carrie? Thank you. Welcome, Kate Dufour from,
Good afternoon or good morning,
good
Senator.
morning, still morning.
It's still morning. Senator Claxton, Representative Meyer, and members of the Health and Human Services Committee. My name is Kate Dufour, and I just want to raise a couple concerns with the amendment. It is everything that we objected to in that it will increase the cost of this program and shift it onto the property taxpayers as well as the state. So everything good, like enhanced reimbursement for this assistance, is gone. And what happens is two things. One is a presumption. Somebody would be presumed, because they are in a shelter, eligible for general assistance. And so under the existing system, somebody applies for assistance and we determine whether or not they are eligible. This presumption is very concerning because we're talking about state and local taxes that are being used. And we need to make certain that every penny of that tax revenue is appropriately expended. And then the other is with respect to Section 2, you're eliminating maximums that we have in place. And as Anna Broom pointed out in the analysis, we brought up the issue of a program of last resort. That's what this program was going to be. When there was nothing else available, then general assistance would step in. And the maximums in place protect the interest of the property taxpayers. So to the extent these are moved forward without any enhanced reimbursement, really just shifts additional burdens on the property taxpayers. And I thank you for your opportunity to speak.
Thank you for that. Any other thoughts, questions? There's a motion on the floor. Are we ready to vote? So a motion is ought to pass as amended. Go to Ms. Withy.
Representative Zager.
Yes.
Representative Zager. Yes. Representative Lumlin.
No.
Representative Lumlin. No. Representative Stover.
Yes.
Representative Stover. Yes. Senator Baldacci.
Yes.
Senator Baldacci. Yes. Representative Perry.
Yes.
Representative Perry. Yes. Representative Griffin. Representative Griffin is absent. Representative Connor. Representative Connor is absent. Representative Craven.
Yes.
Representative Craven. Yes. Representative Madigan.
Yes.
Representative Madigan. Yes. Representative Javner. Representative Javner is absent. Senator Moore.
No.
Senator Moore. No. Representative Meyer.
Yes.
Representative Meyer. Yes. Senator Claxton.
Yes.
Senator Claxton. Yes. That's 8 yes, 2 no, and 3 absent.
And the minority report, Fender?
Ought not to pass.
Thank you. All right. So we have 1, 2, 3, 4, 5 other bills to consider. We've been sitting for a bit. How about if we take a 10-minute break and come back at 11:45 and then work into lunch hour? Okay, we'll on a break then till 11:45. Senator Moore, your background is much better than usual. I always feel like you should be putting stickers on the refrigerator behind you in the other setup down there.
It's actually over there. I'm on the other side of the table because Representative Toole was in a caucus this morning when I arrived. So he was on the other side of the table.
I kind of want to bring you stickers and magnets to go on your refrigerator door.
I have plenty of them at home. I could bring my own. I'll tell you that for sure. I have a very cluttered refrigerator door as a result of that.
All right, so we can resume our activity. Next, we'll go to consideration of LD 629. That bill is currently on the table, so I'd like to have a motion to get it off the table so we can spend some time talking about it. Representative Craven.
Yeah, I move that we remove 629.
Yes,
Thank you.
off the table. Thank you very much. Is there a second?
Second.
Moved and seconded. All those are want to take LD 629 off the table, please so indicate. That's unanimous of those present and voting. Thank you. So that allows us to spend some time working on this task force. We heard, and we'll welcome the sponsor, Representative Reisman. Glad to see you. Glad to have you join us. So we had, when we left this conversation, we were waiting to hear from the judiciary, as has been put up here. And unfortunately, we did. And they begged off the opportunity to be the conveners for this task force. Hospitals had agreed to do some support and getting people in seats, but the judiciary branch thought there was too much of a potential for significant conflict, so opted out of being the convener. So that was a piece that we were missing. I think there was some discussion from the hospital supporting this and from private providers supporting some conversation about what to do in the circumstance of assault when the person being assaulted didn't want to bring a complaint. And is there some other way around that? And that's how we got to a task force. So any thoughts from here? Representative Perry, or did you want to unmute and offer something? You need to unmute. There we go.
Not at this point.
Oh, okay.
Sorry, I'm off in a different direction. So.
Okay. Sorry, I didn't mean to get you messed up there. So any other thoughts about how to proceed with what has to some sounded like a good idea? The options
Are
to be.
are there any nonprofits? I mean, I don't know if there are nonprofits out there that we could team up with or try to encourage. I'm just wondering if there are other entities out there that could be encouraged or that we could work with. I just throw that out there. I haven't been able to give this a lot of thought, but I do think the bill is a good idea, and I know the hospitals are supportive of it.
The not-for-profits that I've worked most closely with, Institute for Civic Leadership or Maine Development Foundation, just because they're not-for-profit doesn't mean they don't charge for convening.
Or the Maine Community Foundation.
Yeah, MCF sometimes will do that. I'm not sure I've seen them do convening for an ongoing task force, but I'm not super familiar with that.
Well, those are the best I could do.
And we also can't direct nonprofits about what to do. We can direct somebody to hire somebody if the somebody is under our purview in the government, but Thank you for that, Anna. Representative Perry?
Just a question that I know we have a number of boards that look at mortality. I'm wondering if, or if there is at least something we can do to begin to look at information that is already readily available, to give us a better sense of how significant this is, and might give us room to move further along.
Senator Baldacci?
Thank you. If we could, I don't know if we can ask the Maine Bar Association actually to see if they, because there are a lot of subsections that they work on, and whether we can ask the Maine Bar Association to work with the hospital group and the state of Maine's. I mean, it might be something. I understand we can't force anybody, but I'm just trying to think of alternatives to advance this issue at some level. And obviously the legal part of this is kind of significant. And I think that obviously the lawyers who deal with a lot of these issues need to be part of it. And the Bar Association, you know, is an important entity. So I throw that out there. I think they might be receptive to it. Obviously we have to feel them out.
The other possibility is to have simply a legislative committee, constitute one, which would allow us to invite the appropriate people in. The other thought related to Representative Perry is that so much of the concern, as I heard it, was that some of these alleged assaults don't get reported because nobody's bringing charges. Nobody's willing to file charges, so they don't show up anywhere on any report reliably. You might be able to get information from a local hospital, but you couldn't get them from all the hospitals. I don't think that's aggregated anywhere, but maybe Jeff Austin can help us with that if you're looking for some other database. So we can welcome Jeff Austin from the Maine Hospital Association.
Thank you, Senator Claxton. Yeah, you put your finger on it. The issue that we want to discuss with some of the law enforcement and judicial folks is how can we bring these cases when the victim, for whatever reason, is not the one leading the charge to bring charges, leading the effort to bring charges. We're just a little unclear as to what the best path forward is to bring those cases. So the assaults occur, but there's no criminal justice record of it because the victim didn't bring the case. So as I said at the hearing, I'm not sure that we're going to change our policies, but we want to know what's in the realm of the practically possible. That's what we're looking to try to figure out with their assistance.
And from your description, that doesn't sound like it would take more than a few convenings to get the right people in the right room and get some answers to those questions.
Yeah, what we're looking to avoid is an anecdotal conversation than defining the statewide practice. You know, you can call one DA or one chief of police and get an answer. And what we need is sort of them to get in the room and discuss this through and help us understand what they want to see from us before we call them and say, hey, look, we really think charges need to be filed in this case. In response, in anticipation of that, what do they want from us so that we can adapt our violence prevention policies accordingly?
Okay. Representative Reisman, did you have a comment?
Yeah, let me just see. Oh, you can hear me. Okay, good. Yeah, I was just questioning when you look at mandated reporting and some other activities, can this not fall into this kind of criteria where we can make it a mandated reporting? That's just a question I'm trying to think. And I see Anna's not too positive on that idea. Outside of that, I think probably Senator Badachi has the right attitude and your suggestion of a legislative committee.
Okay. Representative Perry?
Yeah, I was just thinking hospitals do need to report sentinel events. Do they report, or maybe it might be worth doing that, is reporting any assault or anything like that on a healthcare worker as a sentinel event? It might give also the room for to look at what the event is, and also see how much occurs across hospitals to maybe begin to work on what could happen.
I think we heard pretty clear testimony that it's been recognized as a problem in a lot of different places, and that we're, at least in the minds of the folks who testified, we're beyond how big a problem is it. We're at what are we going to do to address it part of things, which is why
yeah, I'm thinking when we do a sentinel event, there is much more that goes in than just happened. And I think that helps set up, are there things that trigger on a regular basis? Are there, what the seriousness of it, where it occurred, how it occurred. There's a lot more that goes with a sentinel event report than just that. And it might offer at least some good basis to move forward.
Let me go to Representative Zager before I go back to Jeff Austin.
Thank you, Mr. Chair. It's actually a question for Mr. Austin. I appreciate what you said about moving beyond anecdotes. I was wondering if it's your impression that hospitals in Maine have systematic data sets within their institutions, maybe in HR or legal affairs or some other departments that might have sort of like a ready or almost ready-made data sets that could be compiled or made into a composite?
Would you like me to respond, Senator Claxton?
Please.
Yeah, I think by institution, yes, we would have data on some of these, if not all of these events. Again, obviously you guys can go in any direction you want, but let me make a couple of notes. Both Sentinel Event, which is a specific statutory program, and mandatory reporting, which is a specific statutory program, have DHHS mandated actions associated with those reports. So for a Sentinel event, which is something happened at the hospital that should never happen, we operated on the wrong arm. You got to report that to the state. There's an investigation. There's an internal investigation. There's a whole bureaucracy built around that. Similarly, with mandatory reporting, a child shows up with bruising and concerns that there might be abuse. We mandatorily report that to the state, and then the state has mandatory action that they have to take to investigate those cases. So our members, I think, would balk at a mandatory reporting type system here unless they knew what's going to happen. What action is the state going to take in a response? With both Sentinel events and mandatory reporting, we know what the bureaucracy is. We know what they do. So if we report these, okay, to who? DHHS? What are they going to do? Obviously, you can go in all those directions, but we have a distinct question on the table, which is when we know there was an event and we've screened out all of the reasons not to proceed. For example, it is clearly rooted in a mental health case where we're not going to criminalize a mental health diagnosis, where all of the facts point to this is maybe a case that should be prosecuted, but the victim is not willing to go forward. What do we need to gather for evidence? Who needs to be the moving party in dealing with law enforcement and district attorneys? That's what we're seeking out of the bill. All of these other issues about, what caused the violence, what happened, we're doing that on a regular routine basis. Violence prevention is a mandatory activity for hospitals. We have to do this work. So we're trying our best to do it. But when one happens and there is a case that appears that could be brought, this is what we're seeking. I'm sorry to retestify over and over again.
Okay, so Anna, can you review for us or Aaron, the requirements of a legislative committee as an option here?
Oh, right. Let me see if I can bring up my my old bill analysis because I didn't have it handy, but I can kind of talk while I'm doing it. So there is a joint rule associated with legislative studies, and that is around how many people and whether there's a majority of legislators, and there are dates in which it the report has to be done by. And okay, now I can share this again.
So the real challenge is it has to go to the study table if it's
Right.
a legislative.
Right,
Yeah.
that's what I was going to say. So any study would go to the study table, and then the study table, which is the Legislative Council, will determine which ones come off the table. I have not yet heard what amount has been set aside for the study table. Usually when we get fiscal notes for legislative studies, it'll say, you know, there's $10,000 or whatever the amount is for the study table. I don't know that anybody's seen one yet, which suggests to me that maybe that hasn't been yet set. So you would, in this particular case, you would just want to determine how many people, how many legislators, what the duties are, reminder about the judicial branch that you can only invite, the same with the district attorneys, and then who it would report to. And then you have to let it fly. You know, it would go to the study table and they would determine what came off of that. Is that what you were asking for, Senator?
Exactly. Okay. Thank you for that. Senator Baldacci, you had your hand up.
I was going to ask is that in the composition of this committee, I think it's necessary that we have a representative of the judiciary, like the chief judge of the district court, and that we have one or two lawyers. Okay, being I'm not advocating for my profession for any reason other than the basic issue is legal in terms of what will the courts do and what can the courts do. So I think we need to have at least a member, the chief judge of the district court, and somebody from the bar or a couple of attorneys. So I would say 2 or 3 people need to be added to, so that they get that perspective, because the whole issue here is how to handle it from a legal perspective.
And Anna has put up the modified task force membership. So it's 1 from the Senate and 2 from the House, and some of those appointed bys would need to be changed to invited bys.
Correct. And that's the same for district attorneys, we believe.
Right. So we have the last 2, 4, 6 would all be invited bys. 5 through 10. How does that list look to you, Senator Baldacci, since you raised the question?
I think you can appoint law enforcement. It's only the district attorneys and the judiciary.
DAs and judiciary. How does that look to you, Senator Baldacci?
That looks good. Thank you, Mr. Chairman.
Okay. Representative Zager?
Thank you, Mr. Chair. I was going to, in the absence of an avenue through the judiciary that we explored, I was going to move that we ought to pass as amended, making this into a legislative study.
Second.
That's been moved and seconded. Thank you. Is there additional discussion? Anything we should hear before proceeding further with this? There's still some unresolved in the drafting that need some attention. So do you want to put those up and go through those one by one, Anna?
Okay, so the first issue is the joint rules require a majority of legislators. You don't have to do that. You just have to understand that if you don't have a majority of legislators, the Legislative Council could change it so it was. But it is unusual to only have one member of the Senate, because now you only have one party represented. So that's unusual and something for you to think about.
And the other screen that you had up in your analysis listed a bunch of issues that were unresolved or drafting issues that were surfaced.
Yeah.
So one would be the emergency preamble, and my
Yes, that's
sense,
forgotten about that. Thank you.
yeah. And my sense was that there's a certain urgency to this, so getting started sooner than later is a good idea. Is everybody okay with that? Is that considered a friendly amendment, Representative Zager?
Yes,
Adding
Mr.
an
Chair.
Okay. And there should be a report coming back, and various options have been considered along the way. One was criminal justice. Did I get it right this time? Yes.
Mhm.
And so that sounds like a good destination for this report.
You can have it come to you as well if you like.
As
It's
well,
just that
right.
currently there's no committee assigned to this, and that's unusual.
Okay. Well, let's make it cleaner and go to criminal justice. Then we're going to break some rules on 353, but be that as it may. And we talked about invitations to judiciary. Okay. Okay, so is that the language of duties? Can you take us to that?
Yeah, and my understanding, you might want to, I mean, obviously it's your bill, but I do know that Jeff Austin wasn't wildly keen on the changes and that he would like this language. So it's your bill, but I just wanted to make sure that that you knew that.
So to be specific, he wasn't happy with the strikeout in section 5?
No, I mean, he wasn't happy with these suggestions up here of being a bit more specific. He would like the language that is, I don't want to speak for Jeff, but I think he wants this language that was proposed by the sponsor, that the process by which criminal law cases may be brought. He wants that language.
Okay.
I think.
All right. So Representative Meyer.
Thank you, Mr. Chair. I'm just going back to membership and wondering if we add in a second senator, member of the Senate, and then remove, say, one of the law enforcement representatives.
Because other entities who are knowledgeable will be involved, so that would likely be medical and legal anyway.
Mm-hmm.
And we're trying to stay under the 15. We're trying not to exceed 15.
No, it's actually 13.
13.
Okay.
He didn't strike that out yet, but that's why he made 1 and 2 here. But
okay.
you do need to stay 13 or less, or just risk that once again. I mean, you can make it bigger. Just reminder that if you actually have meetings in the State House or cross office building in the interim, you only have so many chairs. But we've had bigger ones before.
We could also cut it down to representatives from, as appointed by the speaker and the president to 1, but that's not ideal either. So
you don't have to have 1 of each from each chamber if you don't want to. I mean, if you want to have, and I'm not telling you to do this, but if you want to have, going on what Representative Meyer just said, if you want to have 1 member representing law enforcement, you can do that. You just have to decide, does it come from the president or does it come from the speaker? You don't have to have all of these even numbers if you don't want to.
Okay. Representative Zager?
I was just going to propose along those lines that if the president of the Senate is going to appoint 2 senators, which I think makes sense to represent both parties, the largest parties, then perhaps the item 5, the representative from law enforcement appointed by the Senate, the president of the Senate, could be removed in order to stay under 13.
That's a simple enough change. So make it 2 on the senators and eliminate item number 5. So that's sort of an amendment that you just made, right? Representative Zager, to your own? Okay.
Yes, sir.
2 senators and no 5. All right. Any other discussions about problems with language or things we surfaced? I'm not seeing any. So with those changes, Representative Reisman, does that sound like a way forward? Keeps us at 13, it gets us a couple senators, 1 fewer law enforcement personnel directly, but still leaves open the option of indirectly. And yeah, and the duties are as in the amended version.
Thank you, Mr. Chairman. I don't want this committee to get too large, but on the other hand, we want to make sure you have enough expertise, and that's why the number of senators had gone down. But I don't have a serious concern with bumping that up to 2 and eliminating number 5.
Okay. And we and guests are always invited. Interested parties are always welcome to participate, and it's a public meeting anyway. So, Senator Moore.
Yeah, thank you, Senator Claxton. I was just going back and looking at my notes, and we may have already addressed this. I had a note that we should probably also include healthcare facilities as well, not only just the hospitals, as far as the scope of what we're going to be looking at. I don't know if we addressed that in any of our amendments or not.
Not yet, unless it's indirectly addressed in the items with expertise, referencing expertise in the area.
No, I'm not necessarily talking about as a member of the committee, but more as what we are asking the committee to, or the task force to look at.
Okay, so make it
Not
a
just
broader-
things that happen in the hospital, but also things that happen in healthcare facilities, because I
Okay,
think they're faced with the same
Yeah,
situations.
it just broadens the duties a little bit. And I don't think anything in there. It says to violence at hospitals in particular. So is the in particular referencing the violence or the hospitals? So we could just say and other healthcare facilities.
That would probably work to make sure we address that as well.
Yeah, no, that's a good point. That was a request from the sponsor too.
Yeah.
Thank you.
Sure.
Representative Zager?
Thank you, Mr. Chair. I appreciate and I would like to extend what Senator Moore just said. Sometimes care is delivered in places that are not technically hospital or healthcare facilities. I'm thinking, for instance, of Scarborough Downs, where there's lots and lots of healthcare being delivered for COVID vaccination, or many other places around. So the committee might consider just some sort of language like where healthcare is being delivered or something along those lines. That would include all the above.
Yep, it sounds like a. So, yeah, a facility where care is being provided.
Well, you could
Healthcare is
say a
being provided.
healthcare setting.
Yeah, that's even more, but yeah, and it's really important in terms of constituting who gets invited and who gets notified to participate. So. All right, so is that enough specificity about the unresolved or the drafting issues for you, Anna, to proceed to put together a draft?
Sure. I know that there were requests for other folks to be appointed, but I didn't hear it in the amendment, and that's fine. I have enough to go on. I believe you want the healthcare setting or healthcare delivery piece in there, which would presumably get you doctor's offices and so on as well.
Okay. All right. So there's a motion on the floor ought to pass as amended. The amendments being to add an emergency clause to increase to 2 senators to eliminate the appointment by the president of one of the law enforcement officers and to broaden the scope to include places where healthcare has been being provided. Anything I missed on that summary?
Criminal justice getting the report.
Criminal justice gets the report. Thank you. I had criminal justice written down. I couldn't remember why. Thank you. All right. So those are the amendments. I guess we can, any other discussion? We can proceed to a vote. Ms. Withy.
Representative Zager.
Yes.
Representative Zager. Yes. Representative Lemlin.
Yes.
Representative Lemlin. Yes. Representative Stover.
Yes.
Representative Stover. Yes. Senator Baldacci.
Yes.
Senator Baldacci. Yes. Representative Perry.
Yes.
Representative Perry. Yes. Representative Griffin. Representative Griffin is absent. Representative Connor. Representative Connor is absent. Representative Craven.
Yes.
Representative Craven. Yes. Representative Madigan.
Yes.
Representative Madigan. Yes. Representative Javner. Representative Javner is absent. Senator Moore.
Yes.
Senator Moore. Yes. Representative Meyer.
Yes.
Representative Meyer. Yes. Senator Claxton.
Yes.
Senator Claxton. Yes. That's 10 yes, 3 absent.
Okay. So Representative Reisman, we have a path forward.
Thank you. I just want to thank the committee for the hard work and support around this issue, because it is time to work this thing forward, and I'm very grateful for your vote today. Thank you so much.
Thank you for being here. Just don't go outside in the sun like the rest of the people who have been testifying remotely and make us jealous. All right. All right. So that'll bring us to a consideration of LD 1570. And we've been joined, I thought, by the sponsor. Yes, there she is. Welcome. And 1570 is one of those that's been on the table and needs to come off the table so we can discuss it. Entertain a motion. Senator Moore.
I'll make that motion to take LD 1570 off the table.
Thank you.
Second.
And it's been moved and seconded. All those and bring it forward for discussion. That's unanimous of those present and voting. Thank you. All right, so that gets us to 1570 and a revision and review of drinking water and Maine residents. Any updates from the sponsor since we last convened?
Thank you, Senator. Yes, I did. I've been working with some of the advocates who have been paying a bit of attention to this bill and tried to, in a helpful way, provide some clarifying information to the committee, which I sent to you all Sunday night, and also copied your analyst in terms of looking at the bill in kind of sections, so that we would have a section that would have specificity around the landlord component, also some specificity around definitions for low income, certainly following what the department had recommended in terms of using the criteria that's already in place through the department for eligibility criteria. And then finally, specificity around the MCL or parts per billion. So I did send that to folks, and I believe that Aaron, you have received it, and we've been kind of working back and forth with advocates also who are in the room if you have desire to chat with Laura Harper or Sarah Woodbury, who, like I said, were instrumental in helping kind of craft that out.
So are you still working off the original draft of the bill as we go forward, or is there a subsequent that you'd rather have us work off of?
Well, there were some minor amendments, I guess I'll say, for lack of a better word, that I had sent to you all, but I guess I'd ask your analyst. I don't think that, Aaron, please forgive me and correct me if I'm mistaken. I don't think anything's yet been crafted officially.
Okay. Okay, so can we put up the most recent version of the possible amendment?
I'm unclear what you mean. Do you mean Representative Gramlich's memo to the committee? Do you mean the
Yes.
thing that I drafted? Or do you mean the thing with Sarah Woodbury's comments? I just don't know what.
I think I'd like to avoid the Sarah Woodbury one for right now because the print will be even smaller. And if we could use, did you draft something as I understand it with Representative Gramlich?
Well, I
I
did,
did
and I
not work-
attached it.
Right. Sorry, Representative.
That's okay, Aaron. I had sent it to Senator. I had sent it to you and Representative Meyer, and I also sent it to your analyst and I believe members of the committee. That breaks out sections 1 through 6 that would
It was
increase.
sent May 16th to all of us at 6:46 p.m.
Sunday, correct?
Yeah, Sunday.
Thank you, Senator Baldacci.
Yep.
So it breaks out sections 1 through 6 under the topic of water testing for low-income households. And then section 7 refers to renters who rely on water, that they be notified of the results of such testing. And then section 8, the bill refers to the parts per billion, if that's at all helpful.
And that's what I've put up on my screen is what Representative Gramlich sent to the committee.
Okay, and I think for right now, we'll go with the italicized words at the bottom of the screen where it says, think of the bill as 3 parts. And we'll go through them in step. So the first is to continue to push for water testing for low income. And my understanding is from the department is that some of that work's already been started. This would be an issue this would be a push to continue broader testing and more extensive testing, and would require some definition of low income and a fiscal note to help expand the program if that's the intent, to get to everybody with a well in a reasonable 5 years as opposed to 10 or whatever. Are those, is that accurate as relates to the first section, Representative Gramlich?
The only caveat to that, Senator, would be to not necessarily have the committee attach a fiscal note, but let the department ascertain what they think the fiscal note might be, because that could certainly be variable.
Okay. Understanding that there is likely to be a fiscal note, depending on what the parameters are that the department proposes in terms of how the speed with which this is addressed or accomplished in testing. Okay. So we can leave that out of current considerations. Does anybody have any question on the first part, which is in what was shown about water testing for low-income residents? And we would be, I heard some discussion about adopting guidelines to include those on Medicaid and or main care and or SNAP as the definition of low income. And that was handy because that's a list that already exists. Those are lists that already exist. Okay. So because there's 3 parts, and in order to get through this, I'm going to ask the committee's help. How do folks feel about the section that's been proposed in terms of well water testing for low income residents so far? I'm looking for a thumbs up if we should continue the conversation, or a thumbs down if there's no interest at all. So I'm seeing some thumbs up. It's not across the board. Okay. So for the sake of progress, let's leave that where it is. Let me ask a question a different way. Are there portions of section 2 that people are uncomfortable with or would like to address and I'll open the floor to that. And it looks like, yes, Representative Gramlich.
Wait, Senator, just because I think it can be a little bit confusing when you say section 2, because the bill has 8 sections
Yep,
itself.
right.
When you say section 2, you're referring to the second kind of that I outlined in my memo. Is that correct?
No, I confuse things, and I will no longer refer to them as sections. I will refer to them by what they intend to accomplish.
Thank you.
And what they intend to accomplish, the one I'm asking about is well water testing. I didn't see universal for low income. I didn't see universal endorsement of that. And I want to make sure that the people who aren't thinking that that should stay in the bill or that they could support that have a chance to ask questions about it. That's what I'm looking for. So I'm not seeing any hands up or any questions. So we'll move on to the next part. I will not use the phrase second ever again in my life. The next part is about landlord arsenic testing and informing occupants. And the change that I'm aware of is from periodically to 5 years for the testing.
That's correct. I just thought that it might be helpful to put some specificity around what the word or term periodic means so that it can have some clarity on how to move forward with it.
Okay. Are there questions or comments related to that? Again, not seeing any. So again, I'll ask the committee for at least a visual indication, not a voted indication, a visual indication about whether this stays in the bill as it's written now. I see some thumbs up. Okay, I see some non-votes. All right. And then the last portion that you referenced is about maximum contaminant levels for arsenic and the move to go from 10 to 5. Is that the third portion that you referenced? Is that the last portion that you referenced, Representative Gramlich?
Yes, Senator, it is. And that has to do with the MCL parts per billion, where we had initially recommended 5 parts per billion. And your last work session, as you'll recall, Representative Meyer suggested doing it within a phased-in approach so that we would reach that objective by 2025, which I'm completely supportive of.
So that's the one amendment, or that's the one change in that section.
Correct.
Okay. Any comments about that? Yes, Representative Perry.
Yes, actually, when this gets passed and stuff, it's really going to be a short amount of time. If it comes into effect in end of 2021, that's 3 years. And 2025 is 4 years, 3.5 years. And I'm really thinking that there's a need for a little bit more time on this. And I'm wondering if we can just put in, municipalities have a lot to deal with. And part of that is they're going to make this change. They need to be the time to evaluate, to see what they need to do with systems, to be able to find whether it be federal or state money to do this work, and then to be able to do the work. And I think as a result, they really need more time to be able to get into this. That is going to be what happens. And also, they're getting hit with a whole lot of other testings. We've been talking about lead, we've talked about arsenic, we've talked about PFAs. You know, I think we need to give them time to catch their breath as well on this. And if we were going to put this through, I would recommend at least a 5-year window.
We have somebody who I think is much more informed about water systems than any of us. If I've gotten that right, we've been joined by Bradley Sawyer. Welcome, Mr. Sawyer. Is there something you'd like to contribute to this?
I'm sorry?
Do you have any sense about the 5 years?
I think Representative Perry made a great point that not only are there a number of things being talked about right now, but the phase-in does, or a change of this magnitude does take significant time. A little background on how that would work for a
Can you just
medium-sized.
identify yourself? Can you just identify yourself, sir, and where you're working from?
I apologize. My name
That's
is
okay.
Brad Sawyer. I am the Director of Government Affairs for the Maine Rural Water Association and a resident of Augusta.
Thank you.
So for a medium-sized utility to large, the way this would happen is they would have folks identify where their water is currently at. They would then figure out where they need to get to and put out an RFP for that process to be created. Different bidders would put forth potentially different ideas as to how that would be accomplished. The engineers and water folks evaluate those proposals, run a test pilot project, sometimes full scale, sometimes small scale. As you can imagine, a full scale test project has to be built out in the state of Maine to withstand full-scale weather. And then that evaluation period can be 12 months, 18 months. It could be a while. And then to make a decision, if you go with your first choice, construction of a full process. If that doesn't bring you the results you want, say your water is somewhere currently at 6 or 7 parts per billion, and that process doesn't bring you significantly below 5 to the point where you're comfortable that you won't cross that line, it restarts again. So I think 5 years is certainly on the low end when considering the funding, and they can go out quite a ways.
Maybe you can help me before we get to Representative Meyer. Are the water systems, and I'm not asking you to speak for everybody, but is there a general sense in the industry that standards for so many of these things are coming down and that improved filtration is a question of when and not whether to get to these lower standards?
Certainly. I think people are they're definitely fearful for everything that is being discussed and feeling like they're going to get multiple major projects at one time. These are folks that collect money from their rates. They're not there making money. They don't, by law, they can't have significant cash reserves. And so there isn't really a feeling that these are inevitable, but there is definitely a fear of all of them happening at once. I think the other piece to that is utilities have been at 10 parts per billion for the last roughly 20 years, maybe 16, 17. And the real arsenic threat in the water community we see coming from private wells and not from utilities. Certainly, we all agree that no arsenic is good, but the difference between 7 parts per billion and 800 parts per billion is sizable. You're not going to find 800 parts per billion coming from a utility, and so there's significant cost required for a small amount of reduction when that funding could likely be directed elsewhere to significantly lower numbers.
And we haven't even talked about PFAS yet, or people who want to reclassify rivers. So, so that's an important consideration too. Representative Meyer.
Thank you, Mr. Chair. I wonder if you could bring in Laura Harper to talk a little bit about some of the rulemaking language from last session's LD 1943 and how that might be able to help guide our conversation around this particular issue.
Welcome, Laura Harper.
Thank you so much. My name's Laura Harper. I work at Moose Ridge Associates. I live in Hollowell, Maine, and Defend Our Health is my client. I worked very closely with Representative Gramlich and Sarah Woodbury on the memo that you saw earlier today, and I thought it might just be helpful if I chimed in here. We've been listening very closely, and we appreciate all the comments that we've heard from your committee, from Mr. Sawyer, from the department. And we wonder if it would be in the best interest of the bill as a whole if we took a different look at this last part of the bill and actually scaled it back and used language that was in the previous water bill that simply directs the department to engage in rulemaking about reassessing the 10 parts per billion. So it wouldn't be mandating the 5 parts per billion. It wouldn't be setting a time like 5 years, 4 years, that it be 5 parts per billion. It would simply be directing the department to do that rulemaking, to examine the evidence and then make a determination. So I don't want this part of, well, we wouldn't want this part of the bill to sink the whole bill. So if that's something that's more palatable to the committee, it's something that we would feel comfortable with.
Thank you for that. I won't ask Mr. Sawyer to speak to that, but that probably sounds okay, more okay to him than a set figure and a set timeline. Please go ahead.
Certainly, we did not testify in opposition to 1943 last year, and if the department is directed to undertake rulemaking with no presupposition of where they end up or interim rule, we would find this bill much more palatable.
Very good, thank you. All right, are there any other questions along the way here? Any concerns? I'm not seeing any. So Representative Zager.
Thank you, Mr. Chair. I move off to pass as amended.
Second.
Seconded, and thank you for that. And Senator Moore.
Yes, thank you, Senator Claxton. Would you mind just summarizing the amendments that we are coming up with? I'm a little overwhelmed with that.
Catch me if I refer to section or number, okay? So the first portion of the bill relates to a well water testing for low-income residents. Low income defined as either receiving main care or SNAP. That's the population to whom this would apply. So that's the initial portion. The middle portion would reference landlord arsenic testing and make it a every 5-year occurrence. And the last portion would change the interim maximum contaminant level to a rulemaking process that the department undertook. So Representative Gramlich, did I get portions initial, middle, and final right?
Senator Claxton, you were outstanding.
Okay, Senator Moore, did I answer your questions?
Well, the only other thing is that there was some questions about the first part, increasing the water testing. And the department has an ongoing program that they're doing X amount of wells for the low income housing per year. Were we addressing, because they were saying they would probably need additional chemists if we were going to define the numbers, for it to be all of them or something within reason?
This bill doesn't define that. This turns it back to the department to set up a strategy and a way forward.
Okay. I see that Molly has her hand up. I don't know if she has a comment.
I know, but I'm taking
Okay.
care of my committee first.
Okay. And then
All right.
there's part 2, we said every 5 years, and there was somewhere I read something that the landlord had to notify them within 10 days. Are we leaving that out?
I don't think the reference to 10 days was stayed in the bill.
Okay, good. And then I'm very pleased with the section 8, with the part 3 part of it, with the rulemaking process, because it is at an expense that the municipalities that have those community water systems, it could be hefty, but if they start going with it. So I agree with the rulemaking. I'm fine with that as well.
Yeah.
Thank you for the clarification. I appreciate it.
Important to get these things right. Molly Bogart.
Thank you. This is really helpful for us. I think the two pieces that we would like some clarity on, I appreciate the committee's latitude for having us develop that the vision for the outreach to low-income families, but I do think that we need a little bit more clarity from the committee as to what they're looking for. If you're telling us to increase outreach, that is one thing. If your intent is to have us, reach out to every family on main care, for example, that is an easier thing for us to implement because we have a clear understanding of what we're trying to develop. So guidance like that, I think, would be really helpful. And then the other question that we had was around the envisioned timeline for that rulemaking. As you know, there are a lot of other rulemaking priorities that you've passed. And so if there is no timeline on that rulemaking, that would certainly be helpful for us so that we could appropriately prioritize things like PFAS and others. But I do just want to make that expectation clear so that we don't come back in 6 months and have there be an unarticulated expectation that the rulemaking is done.
So let's go to the sponsor. Do you want to speak to who all should be surveyed or encouraged to get their wells tested?
Yes, thank you, Senator. I think Ms. Bogart's suggestion to reaching out to folks as defined on main care or SNAP is an appropriate approach to take.
And that would be all on that list to reach out because we can't get the testing done. And then the next question is, do you have a timeline for having this happen?
The outreach?
Yes, we can't guarantee that anybody's going to do anything. Is our goal to get to everybody with this information in 1 year, 3 years, 5 years, 10 years?
Well, certainly not 10 years.
I just put out some possibilities.
Well, anything's possible. This is true, Senator. I think that if we're leaving it to the department to, kind of move forward with rulemaking, I'm going to trust that the department is going to understand that this is a priority and that they're going to work this as quickly as they're able to. I mean, I know PFAS is something that is a big priority as well, and I certainly wouldn't want to be one to compete arsenic with PFAS.
All right, Molly's looking for additional definition then beyond that, and we haven't gotten to the arsenic rulemaking yet. I understand that. Go ahead, Molly.
And that's very helpful, although I'm not expecting there would be rulemaking around the outreach, just to clarify.
Right, no, I understand.
Great.
But so three is less than 5 and more than 1. Does that give the department enough time to reach everybody who's got a well in the state and quantitate what the cost of that process would be?
Sure. I mean, I think the outreach can happen relatively quickly and, quickly in the state government definition, but
let's say, how do you define quickly?
As soon as we can we both receive the funds and develop the plan and do that outreach. So I think the timeline was more concerned about the arsenic MCL, but
Yes.
The other question we did have about the outreach was whether the committee would be comfortable with us prioritizing within those populations. So there are about 220-ish cases in main care if we either did a staged approach or prioritized families that live in communities where more than 50% of people are on private wells, or if we do some of that targeting. Is that something the committee is comfortable with? Because we know that, there are certainly plenty of folks on main care who rent or may not be served by a private well. And so I just want to clarify whether you are comfortable with us doing some of that targeting as we draw out this program.
I see some head nodding, and the goal here is risk reduction. So you go where the risk is highest. I'll just speak for the committee. That's the one time I felt comfortable doing that. So I defer to the department as part of their non-rulemaking process to come up with a plan that most effectively gets to those folks. And if it works better by neighborhoods, because now I got my well tested, when is your getting tested? That's an additional win potentially. So we leave that to the department.
Great.
All right. So that leaves unresolved. Yes, Senator Moore.
I think you're just getting to that, Senator Claxton. I think one of the other, as I heard Molly talking about, was the rulemaking process for part 3.
Yep.
And allowing them to set their own timeline instead of us putting a date on it. I think I would support that.
And just for the record, that is the final portion, not part 3. That's the final portion of the 3. All right. So how do folks feel about not defining a timeline for the rulemaking around arsenic levels? It's currently at 10. Are people okay leaving that undefined? I'll look for a sense of the committee with a thumbs up. Is that all right? We defer to the committee to defer to the department to take care of that? I'm seeing some thumbs. Okay. All right. So yes, Representative Gramblick.
Thank you, Senator. I know that you were kind of putting it out there and because anything's possible when you said 10 years. And I just want to reiterate that appreciate Senator Moore's comments and everybody's work on this. And I'm wondering if we can maybe have a little bit of specificity in terms of including an opportunity for the department to report back to this committee what their progress is, so that you all have an understanding of, there is movement towards the end objective of having that part per billion defined.
I have anybody think that's okay? I'm going to report back on an annual basis about how the process is coming. I think I think that's probably the safest way to do it as part of our orientation time or our regathering time on odd sessions, short sessions. That keeps it front and center. And we've asked this as a part, and I assume that they get a bunch of really smart people in a room together. They're not going to not talk about arsenic if they're already talking about lead and uranium and PFAS. So I assume that there'll be some aligned progress. Senator Moore.
I was just going to make a comment. We've been getting the drinking water report. So that might be a good part of that report itself to let us know how that's going and what the progress is, just as a thought.
We'll call that the Moore Amendment. All right. Any other thoughts or conversations? Oh, we've been joined by Representative Griffin. Would you care to say hi and introduce yourself?
Sure. My name is Abigail Griffin. I represent House District 102, which is Glenburn, Levant, and Kenduskeag. And I apologize for being late. I had a public hearing in another committee.
We've had people popping in and out all morning long, so glad you could join us. All right, so you're just in time for a complicated, and I'm probably not going to do the recitation right. Do you have enough specificity, Aaron, to proceed with drafting a final-ish bill?
I would like to repeat it back to you just to make sure I'm on the same page. There was another drafting question about the landlord arsenic testing piece. That promptly is a squishy word, just like periodically. And it looks like periodically had some definition that you've discussed, but promptly has not.
Okay. Well, I understood the testing to be every 5 years. And what are you missing then?
The notice to the tenants. It says it should be provided to them promptly, which is,
okay.
I mean,
yes,
unenforceable, really.
Right. Well, promptly is unenforceable, but 30 days. Representative Gramlich.
I thought that, and again, I'm just trying to toggle between two screens here, so I don't have the document right in front of me. but I thought that we had some, in one of the iterations, a reference to within, that said to inform the tenant within 10 days.
And I had understood that at one point, but then when Senator Moore asked about that, I was looking at the original bill and it doesn't include that. So I told her that wasn't going to be included. So I think we probably legitimately need to go longer than 10.
Yeah, so what I've been hearing this afternoon is that you're working off the original bill and identifying the things you want changed from that original bill. And so if it hasn't been mentioned this afternoon, I know that there are a whole bunch of other topics that we haven't picked up this morning related to this. So if it hasn't been mentioned, I wasn't planning on changing it because that's unclear.
Me too.
Okay, Representative Perry?
Yes, there's other testing that has to go on by the landlord, if I'm correct. And what has been the requirements for notification to the tenant in other areas?
That's under the radon testing section. I just need to pull up that. Radon testing requires the landlord to, within 10 days of receiving the results of the test, with respect to existing tenants or before a tenant enters into a lease or tenancy at will or pays a deposit to rent or lease a property.
Why don't we be consistent and have that be the same?
So I misinformed you, Senator Moore, based on my understanding, so I apologize for that. The language is 10 in the amended version, which I didn't. I lost track of my versions. If that makes a difference. So to be clear, and to answer the question that Aaron asked, we're working off of the amended version, so you're not bringing up anything else that was part of any questions you had about the original version.
I don't know what amended version you mean. There are three different iterations of this out there. Yeah, I'm sorry, I'm losing the thread here.
Representative Meyer?
Thank you, Mr. Chair. There is no formal amendment.
Right.
So I think that's where the confusion is. So it's my understanding that, well, there's a motion on the table and I'm not entirely sure we know what it is we've moved and seconded. What I think we have moved and seconded is what we hope to see Aaron create in an amended version. And that would include the testing of low-income mainers, the landlord and tenant piece, which we're trying to flesh out how much time landlords have to notify tenants, and returning back to the language, the rulemaking language from 1543, if I have that right, from the 129th.
1943, Representative.
Thank you. That's my understanding of what is in front of us right now. And the rest of what may have been in a rather complicated original bill, we are not considering. Does that help, Aaron?
No, I'm really sorry. I'm really trying here.
Why don't you think about it a minute, Aaron, and I'll hear from Senator Moore.
Thank you, Senator Claxton. And I can kind of understand, Aaron, where you're coming from on this. What's so bad is that we're looking at a proposed draft, and it had all of these things about landlord arsenic testing, which then tended to really confuse the issue and had the fining and so forth. But if we go back and look at the original bill, that's where we got into the landlord shall periodically, which we didn't have a definition. Now we're saying every 5 years, and the landlord should notify them. And we said that should be 10 days. So I think the initial wording is where we want to work from, as opposed to even disregarding the draft of an amendment that becomes confusing. Does that help, Aaron, a little bit?
I understand that the sponsor has bullet points. I would say that we should be looking at the original bill and
Right.
identifying anything you want changed from that. And if the sponsor's proposed bullet points are your guide for those policies that you want to see or not see, then that's fine. Like, that's your prerogative to do that. But where there's so many different moving pieces,
Yeah.
we really just need to stick with something that everybody has in front of them. Because even some of the small pieces we've talked about don't fully capture, I think, the program as it's been proposed or discussed, if we're just looking at kind of starting from scratch.
So I think we're proposing at this point, and I appreciate your push to help us get clarity. I think it's easier for me to understand working off the original document and highlighting what we want to keep and what we don't want to keep and what we want to change and we won't want to change off the original document. The other thing I'm aware of is that it's 1 o'clock and we haven't had a break for a while. And people are probably a little tired and a little hungry and maybe need to take a half hour to grab some lunch and then come back. Senator Moore, you've asked some good questions. What do you think about going back to the original bill?
I think that would be the least complicated for us to do exactly that and work from it, because it has a whole lot less words so that we can make those
Right.
make the modifications. I think that's a great idea.
Okay, Representative Meyer, you've summarized the three portions that are most deserving attention. Are you in agreement we should go back to the original bill?
Absolutely. However it is that we can bring the committee to an understanding of what we intend to strike from the original bill.
Okay.
And
What about
we,
the idea of a half hour break for lunch now until 1:30? People, thumbs up or thumbs down on that one? I'm seeing some big thumbs up. All right, we'll adjourn then until 1:30. We need a break, and we'll come back starting with consideration of the original bill. So I think it being a little after 1:30, we can resume our work. For those of you who are tuning in, expecting to hear about a managed care program for main care services, that's been delayed while we finish up this morning's work on the bills. We still have 4 to conclude. We're working on one of them currently. So when we left for the lunch break, we planned to come back to the original bill and make sure we understood we were all on the same pages about what we were agreeing to. Before we even do that, I would ask that Representative Zager withdraw his motion so we can start fresh. It's too much has transpired since.
Happy to, Mr. Chair.
Thank you very much, Representative. I think so. We're starting with a fresh start. Okay, and I see that Laura Harper has her hand up. Did you have something to contribute at this point, Laura, or is that hand still up?
Thank you so much, Senator Claxton and members of the committee. If it's helpful at all, I'm happy to walk the committee through the original bill language and articulate in each section the changes that we've heard, incorporating what we've heard today, what we heard last week, and the sponsor's amendment that she offered when she first testified at the public hearing. But if that makes it more complicated, I don't need to. I just wanted to make that offer.
I'm up for trying differently than we were doing. So if you're willing to start and stay with the language of the original bill, except as highlighted, that would be helpful.
Okay. So I'm going to pull it up on my screen. I know I can't share, and that's totally fine. So I'm looking at the original bill as printed, and I'm going to go section by section. So section 1, no changes. Section 2, this is the important section we've been spending a lot of time on, this new language here. So what we've discussed so far is that we need to define low income in the establishment and the maintenance of this program for low income residents to get the free testing. And I think I've heard agreement that we're going to use the same eligibility guidelines the department suggested here. The other piece in this section that was in the original sponsor's amendment back at the public hearing was to reference this to existing statute where the CDC recommends a whole slate of tests. And so that's a decision I think we were at a place where we thought you had already adopted that. So that's a change that you could put in here or not. Shall I keep going?
Yeah, why don't you keep going?
Okay, so section 3, no changes. Section 4, no changes. Section 5, no changes. Section 6, no changes. Section 7, so this is where we get to the landlord tenant arsenic testing. So one of the things that was in the original sponsor's amendment was to clarify that this does not include commercial leased property. This is just residential leased property. So you may want to consider clarifying that in your final amendment. And then of course, what we've discussed today and last week was defining periodically every 5 years and adding a time frame on the notification. We prefer 10 days, but as long as it's clearly defined, we're fine with that. The other piece in here, again, that was in the original sponsor's amendment was, again, not limiting this to arsenic, but having it be the whole slate of recommended testing that the CDC recommends. So again, that's a decision that you can decide to add that or keep it just to arsenic. And then the last section, section 8, is around the public and community water systems. And what I heard from the committee, the discussion was that we could change this to just be a directive for rulemaking, not put in a mandated 5 parts per billion or an interim level, but use the simple language that was from the bill 2 years ago that just said the department will engage in rulemaking to re-examine the acceptable parts per billion of arsenic. And that's the bill.
Okay. Any questions based on that review of the original language of the bill before we consider some of the unresolved points? All right. So the expansion of the slate of tests from just arsenic. Is there any sentiment in support of that at this point, or to limit it to a bill about arsenic? Representative Meyer?
I would, thank you, Mr. Chair. I would rather limit this to a bill about arsenic.
Anybody want to argue otherwise or lobby for otherwise? So we would not be expanding the slate of tests beyond arsenic, at least in this legislation. Whether it gets done that way or not is not what this is about. Okay. So is that your feeling also about section 7 in the landlord arsenic testing? Representative Meyer? Yeah. Okay. All right. So we would not expand it there. And then the other piece that was highlighted by Ms. Harper, thank you, Laura, was that section 7 doesn't apply to commercial property. So we could include that in there. Okay. Senator Moore.
Thank you, Senator Claxton. Going back to that section 3, where we were saying the testing, do we want to, I think we had talked about allowing the department to prioritize the actual testing itself, the cases themselves. You know, they mentioned if they had an area that had 50% of the area was in, were supplied with well water, that they would do that as a priority in sending the information out. We talked a little bit about that. I didn't know if we wanted to incorporate those words.
Yeah, and I personally was comfortable with leaving it to the department to prioritize. We trust them to prioritize so many other things. I don't want to put that in statute if I can help it. That's
Okay,
my
and
feeling.
that's fine. I just want to make sure that's that is what
Yep.
the unintended. Great.
Any other questions, comments? So thank you, Laura Harper, for walking us through that. Let me ask, does section 1 materially help in this work of getting low income water? Or is that section 1 is really about making it available to lower income folks at a more reasonable price? Is that what I understand about this, Laura?
I'm so sorry, I took my video off.
Yeah.
So you're
section
talking
1.
about part 1 or section 1?
Section 1, top of the
Okay.
first page, where it
These are
says,
all of these sections 1 through 6 most of them are making tweaks to accommodate that
Right.
paragraph where we're directing the department to establish and maintain that program of free testing.
but so there's very little change in any of those sections through 6.
No, I mean, I would rely on Aaron's technical
Yeah.
expertise
Yeah.
if any of those need to
Okay.
be tweaked to adjust around the paragraph that establishes the program.
Okay.
The section 2, I have it up in front of me now.
Yeah. Representative Perry? When you're unmuted.
Yeah, I was just going to make a motion ought to pass as amended with what we just went through.
Okay. Is there a motion second? There's a second. Okay. All right. Thank you, Representative Perry and Representative Stover. All right. Is there additional discussion? Senator Moore, is your hand still up, or did you have another question? Yeah.
No, it's still up. When we went over the part about the landlord arsenic testing, and we did say it was going to be residential, I didn't hear, did we say, were we going to include that every 5 years to define the periodical? It says periodically test.
Yes, that was my understanding. It was 5 years.
Okay.
And we had not officially said about the notification timeframe, whether 10 days was okay or not. But at least it's consistent in statute if we stay with 10.
Right. So we want to make sure we include that in the amendment. That's what I'm trying to point out.
Yes, thank you. Thank
Sure.
you. Representative Meyer?
Thank you, Mr. Chair. I just want to be sure that our analyst understands, is clear on what the committee is poised to take a vote on.
I'm happy to repeat back to you my understanding of the discussion thus far.
Thank you, Erin. Thank you.
Very good.
So on the well water testing piece, you are defining low income to include recipients of main care and SNAP. You're not going to put up an appropriation in order to let the department determine the costs based on how the bill is drafted. You're going to specifically, I think, direct the department to undertake outreach related to informing people of the ability for free well water testing, and that the department would have the discretion in prioritizing that outreach, and that the test would be just the arsenic test, not the fuller comprehensive test. And so within that first topic, the other existing pieces of the bill remain unchanged, which is it would exempt it from the typical testing fee that would be associated with water testing through the Health and Environmental Testing Laboratory. And something that wasn't discussed was that it puts it as an authorized use to have the testing program potentially be funded through the Private Well Safe Drinking Water Fund. And that those would remain unchanged. So that's what I have for part one. Is that accurate?
The only question I had about that was whether you wanted to include language directing the department to prioritize or do otherwise, or just leave it to their discretion, whether you want to include that language at all. I don't see any reason to include it, really. Representative Perry?
Yeah, I would just recommend we leave it to their discretion.
So
Yeah.
Say nothing. It would be
Yes.
silent.
Yes.
This is what I have for the second piece, which is generally about landlord arsenic testing. So you would keep the same structure that exists in the original bill, that you would change the word periodically for the testing frequency to every 10 years. You would change the word promptly in relation to notification of tenants to 10 days after the test results, that you would keep it limited to existing tenants, not prospective tenants, that the test would be just an arsenic test, not a comprehensive test, and you'd clarify that it's residential landlords only.
Yes, Representative Perry?
Erin, I heard you say to every 10 years, and I think we had agreed on every
I'm sorry, 5 years. I got my 10s and my 5s. Yep, 5 years, 10 days.
For the periodic
Yep.
change.
Okay.
So part 3, so that would mean you would strike all of section 8 of the original bill, and you would put, I think, an allocated language, like in 1953 from last year as originally drafted, that directs the department to review recent research regarding arsenic toxicity and levels suitable for consumption, and amend the drinking water rules to revise the maximum contaminant level for arsenic to be consistent with that research. And you would not put an implementation date of when the department would be directed to adopt the rules, and you would require an annual report back to the department as part of its drinking water report, I guess on the status of the rulemaking, but I don't know if that should go away once the rules are adopted or not. So that's a question I have for you.
Yeah. That'll expire at the point at which rules are adopted.
And so it wouldn't be a separate report. It would be part of the existing annual drinking water report.
Right.
Okay.
Right. Any questions about that? Is that adequately summarized for everybody? All right. So then it sounds like we're ready to vote on the motion, which is ought to pass as amended. The amendments just having been reviewed. So I guess we can go to Ms. Withy for a tally.
Representative Zager,
Yes.
Representative Zager, yes. Representative Lemlin,
Yes.
Representative Lemlin, yes. Representative Stover,
Yes.
Representative Stover, yes. Senator Baldacci,
Yes.
Senator Baldacci, yes. Representative Perry,
Yes.
Representative Perry, yes. Representative Griffin,
Yes.
Representative Griffin, yes. Representative Connor, Representative Connor is absent. Representative Craven,
Yes.
Representative Craven, yes. Representative Madigan,
Yes.
Representative Madigan, yes. Representative Javner, Representative Javner is absent. Senator Moore,
Yes.
Senator Moore, yes. Representative Meyer,
Yes.
Representative Meyer, yes. Senator Claxton,
Yes.
Senator Claxton, yes. That's 11 yes, 2 absent.
Thank you for that. Thank you for the help from Bradley and from Laura, and thank you, Representative Gramlich.
Thank you, Senator, and thank you all for your deliberate work on this. I know you've got a full agenda, so I'm going to leave to go back to the Taxation Committee.
So long. So the next bill is 1090. Do you want to take over the chair? Because nominally I probably shouldn't be doing that since it's my bill, Representative Meyer.
Yes, indeed. Thank you, Senator. LD 1090. Yes, Senator Moore.
I believe this bill is tabled, so I would make the motion to take it off the table.
Thank you. A second. We'll do a show of hands. Thank you, Senator. So this bill has had a work session, and I believe its sponsor has been doing quite a bit of work around it. So I would welcome Senator Claxton's input.
Thank you, Madam Chair. I'm not at all clear why the progressive treatment program isn't working the way it's designed in Maine, or why it's not working the way it is in many other states. And my hope is that Representative Perry's study group will be able to answer some of those questions. We tried to address the financial limitations for some agencies and entities, but we couldn't find anybody who's willing to administer the funds. So we tried a number of different options, including judiciary and DHHS and the folks in the AG's office, and that didn't work either. So a specific request I'd heard from advocates is that there be inclusion of psychiatrists, psychologists, and ACT team members on the task force that Representative Perry's bill put together. So I'll look to her for affirmation that that in fact did happen. And then the issue is with no reasonable way forward about making this happen, whether I continue to work on it in the interim and bring back a report, or whether we decide that this ought not to pass at this point. It's painful for me, and I got involved with what I thought was a simple bill, but it's a matter of turning over too many rocks and finding out what's underneath. I had hoped for some resolution to this that would recognize the needs and benefits of this to so many residents and so many families in our state, and haven't been able to figure out a way around that. But it's very disappointing, and a task for me to continue to chip away at this to try and find some pathway forward. But this bill right now, as it stands, doesn't offer that pathway. So I defer to the committee.
Thank you, Senator. Senator Baldacci.
Thank you, Madam Chair. I first of all want to thank Senator Claxton for the enormous amount of work. This is an important bill, and I share his frustration. I have concerns. I mean, I would prefer carrying this bill over and then seeing what can be done in the interim, because if Representative Perry's committee can come up with some solutions, maybe we can amend this bill further. But in the alternative, if that is not something the committee wants to do, I would want to make sure we give a specific directive to that committee to find a place that can administer the funds, whether it needs to be a state agency or whether it can be a nonprofit or whether it can be some sort of consortium of the two. I don't want to let this issue go away. I don't want to let the work go to waste. I think this is a very important piece of all the things that we're trying to do to improve the system for the patients as well as for the communities. So I would just ask if we could either carry it over or if we can ensure that there'll be a specific directive to that committee, and whether or not that committee is able to report out legislation back to us. Thank you.
Thank you, Senator. I would just ask Representative Perry if you might unmute yourself and weigh in on whether or not you feel your task force could be given an additional charge as articulated by both Senator Claxton and Senator Baldacci to, I assume your report back is to our committee?
I assume so too,
Yeah,
on that
so-
part. And now, have we passed that bill? I'm really sort of yet.
Aaron.
Yes.
You passed 869 last week. You expanded the membership. You expanded the scope of the duties to.
Right. So, so would we have to reopen to broaden the charge, or can we as a committee just send a letter to that committee saying this is another piece? Because I think the charge was really for everything.
It was to look at the I guess the lifetime, for lack of a better word, of the PTP process, both from the application to implementation. It was broad about PTP, and it did have the Perry Amendment on it to report back to the committee with the authority to report out legislation.
Yeah. So what we could do as a committee just is, once that gets set up, just have a letter looking at this bill and saying that this is an issue that we want to be sure that they're aware of. And that might be the easiest way to do that.
Senator Claxton, your thoughts?
That sounds very good to me. This started out as a somewhat of a intellectual exercise. I really had no real investment in it until I began to hear some of the stories and understand the true implications of this bill. And now it's a much more tender issue than I anticipated it's being. So anything that makes progress, and as long as there's the Perry Amendment on the Perry bill, and we have the option to introduce legislation when it comes back to us in January. I'll still be doing my sleuthing and lurking on the Perry committee, but I'll continue to work on this, and I appreciate the committee's indulgence with several work sessions on this, trying to get it right.
Absolutely. Representative Stover.
Thank you. Senator Claxton, I want to thank you for bringing this bill forward because I think this is a much needed piece of legislation, and I'm sorry that you haven't, that the money side of it and some of the other pieces just haven't presented themselves yet, because I have faith that with working with Representative Perry's task force, that I believe this can have promise. So with that, I would like to make a motion on this bill ought not to pass.
We have a motion on the table. Do we have a second?
I'll second it.
Any further discussion? Seeing none, I would ask Ms. Yes, Senator. Is your hand up?
Yes, it was.
For further discussion?
Thank you, Madam Chair. I just want to indicate that, as I said, I believe Senator Claxton's doing yeoman's work on this, and I hope to help him if we can, because I think we need to find a home. I'm going to vote. Our vote of ought not to pass is no reflection on the bill itself. I am totally committed to making sure that through Representative Perry's work that we try to find some answers so that we can come back and fix the solution, hopefully in the spring or early, late winter. I think it's an important issue, and I don't intend to let it go. And I know Senator Claxton and others feel the same way. So I think that through Representative Perry's bill, we can get a lot more detail done so we can come back even stronger. And so I really appreciate his work and everybody's support on this committee. Thank you.
Thank you, Senator. Any further discussion? Seeing no hands up, I'll ask Ms. Withy to run the vote.
Representative Zager.
Yes.
Representative Zager. Yes. Representative Lemlin.
Yes.
Representative Lemlin. Yes. Representative Stover.
Yes.
Representative Stover. Yes. Senator Baldacci.
Yes.
Senator Baldacci. Yes. Representative Perry.
Yes.
Representative Perry. Yes. Representative Griffin.
Yes.
Representative Griffin. Yes. Representative Connor. Representative Connor is absent. Representative Craven.
Yes.
Representative Craven. Yes. Representative Madigan.
Yes.
Representative Madigan. Yes. Representative Javner. Representative Javner is absent. Senator Moore.
Yes.
Senator Moore. Yes. Representative Meyer.
Yes.
Representative Meyer. Yes. Senator Claxton.
Yes.
Senator Claxton. Yes. That's 11 yes, 2 absent.
Thank
Could
you,
I
Carrie.
just say,
Go ahead.
could I just say something to the folks who are listening in? I hope you understand from what you've just heard the breadth of support for the program and the commitment to finding a way forward. And I appreciate your advocacy along the way. Thank you.
Thank you, Senator. And you took the words right out of my mouth. So I would ask at this point, since the committee Democrats did not have an opportunity to caucus final, or actually 1437, if we could have the benefit of a very brief corner caucus in order to do that. Senator?
We also have 949 to consider too.
Yes, we do. And perhaps we can discuss that as well. But just a brief corner caucus before we move into the next two final work sessions.
Thank you. Okay, so we can resume our deliberations. Let's go next to consideration of 1437. Or just, as it stands now, it's been voted on. It was ought not to pass last week. Is there a, yes, Senator Baldacci?
Thank you, Mr. Chairman. I would move to reconsider it.
Motion's been made. Is there a second? I don't see any. I'm sorry, Chris, I don't see a second for this. So it stays having been voted on the way it is. Appreciate the passion. I think the expression is ran out of runway. So it's not going to happen. I'm
Mr.
sorry
Chairman, can
about
I
that.
ask, obviously, I think at some point we need to, revisit some of these issues. So I'm hopeful that we'll be able to do so in the future. I'm sorry the committee didn't want to reconsider it, but I would just agree that I appreciate Representative Kessler's work on this. Thank you.
Thank you. All right. So that brings us to consideration of LD 949. Senator Baldacci, do you have something to offer? But before we do that, we need to take it off the table.
So I would move to take it off the table.
Is there a second on 949?
I will second that.
Second, okay. Motion made to second. Please indicate with your hands that you want to discuss 949. Very good. Or a thumb in some cases. So I understand you have an amendment, Senator Baldacci.
Yes, I think that after a lot of discussion and deliberation with nursing homes and their representatives, I offer this amendment to add a total of 32.5 million in funding for nursing homes. 20 million of it would be coming from savings that the state has already realized because of one, reduced occupancy rates, and also because the FMAP federal matching funds have increased. That's where 20 million would come from, and the 12.5 million would come from unspent CARES Act funding from the December 2020 CARES Act bill that passed the Congress. I think this is vitally important. Nursing homes across our state are operating on thin margins. They take care of the most vulnerable citizens, some of the most vulnerable citizens in our society. In District 9, which is Bangor and Herman, there are well over 1,000 seniors receiving this type of care. It's extremely important to, I'm sure, everybody's constituency and to the whole state. So I think it's really important that we help financially stabilize our nursing home industry and make sure they can take care of our seniors, particularly in a state where we're all aging and it's an aging population. So thank you very much, Mr. Chairman.
Thank you. Do folks have the amendment handy? Is that something maybe you could put up for us, Anna? That would be helpful, I think. So what's the wish of the committee? So there's emergency preamble. Because the nursing homes are articulating an acute need. And on the next page.
Can I just make a couple of questions?
Please.
Can I ask a couple of questions here? So the first is, I'm wondering about this language that says the department has failed to provide sufficient state and federal funding. That's unusually blunt, but it's up to you. But I don't think we can refer to the change package in the preamble, I understand that the preamble isn't law in the same way, but I don't think we can refer to the change package. And this is a very long preamble. So I'm just going to put that out there for discussion, but
Right.
then move on. I have a couple of other questions as we go along too. So just tell me when you want me to zoom up, Senator.
Okay, so 20 million of state funds.
So I do want to mention that we
And FMAP.
can't, somewhere in here it says something about January 1st. Yeah. We can't my understanding from Luke is that we can't go retroactive to January 1st because we're already past March and we can only go back to the quarter that we're in. This is from Luke, who knows much more about this than I do.
Well, I think we'll have to get consultation from Luke. I would assume that the legislature could go back retroactive regardless.
We cannot, actually. We can only go back to the quarter that we're in, is my understanding.
Oh, wow.
And
so I think, Anna, sorry, I'm going to jump in. I think it's to get the federal match. You can only go back to the quarter you're in. So it would be entirely state funded for any period earlier than that.
Yes, thank you.
You can go back. It's just the funding source.
Okay.
And my assumption was you wanted the match, but you're right, Erin. Thank you for that. The other thing that I was going to mention, and this is also from Luke, is because you have this language in here about savings realized in the course of the current state fiscal year in the nursing facility line, because we don't necessarily know where that, if that money is still available, it's not necessarily sitting in an account somewhere, is that will lead to what impact this has on other programs cannot be determined language in the fiscal note. So I just want to give you that heads up that that's what the fiscal note will say, because you don't know if that money is still there just because there may have been less reimbursement to nursing homes. So that's just another heads up from Luke.
Yep.
And you can tell me
This reads like preamble. This reads like preamble. Those savings in state funds are estimated to be over 30 million. So obviously that doesn't go in statute.
Some of this doesn't have, it doesn't look like this, but that's fine. We can, I'm sure that between Luke and I in the department, we can figure out how to word some of that, but you're absolutely right. It wouldn't be worded this way. And that's because you don't have the appropriations in here either. And that's fine. We're not going to encourage Senator Baldacci to do his own appropriations sections. That's all right.
Thank you.
Would you like me to move down?
Sure.
So this is the PNMI section. I noticed there's also no rulemaking in this particular section. Maybe you don't need rulemaking, but it seems like when you're allocating money, you might need something. And July 1st is coming right up too.
And section 2 there, again, it's the reference to a 12.5 million remaining, and that's speculative. And they won't get out the door by July 1st if we're voting on June 15th.
Even with a preamble, right? I mean, if for no other reason than, anything that's on the table, I mean, the table is one of the last things that happens in the legislative session.
And other than that, if we want to go retroactive to 1/1, that's all general funds,
Right.
that 3-month period.
And I don't know that this one has that. It's only in section 1, I believe.
Okay, all right.
And then I thought we'd done the cost settlement thing, but maybe this is different, but I thought and Molly will tell me if I'm wrong, but I thought this was the section that was in the other bill where the department is not cost settling, but maybe this is different money, and that's why maybe I'm wrong.
This is different money, but yeah.
Okay. Whoops, sorry, that was my getting dirt off my mouse. Sorry.
Jumpy mouse. All right.
Yeah. and then you have the summary.
So, yeah, Senator Moore.
Thank you, Senator Claxton. I guess I'm a little troubled with a couple of the sections in here, and I totally support our nursing homes and PNMI, the funding. I know how hard it's been this whole pandemic. What I'm concerned about is the wording that we've got in both sections that says the department is further directed to allocate the combined state and federal funds fully, leaving no money unallocated. I mean, I have a real problem telling the department you have to, spend that money and you have no money left over. So I'm not real comfortable with that in both of those sections.
You mean you don't keep your bank balance at zero?
I'd have some checks bouncing, that would be for sure.
I guess I can't quite tell exactly how the reimbursement is distributed. And I can't tell from this language how exactly this is allocated. I mean, it says increased reimbursement rates, but is that it?
I think that the unallocated, the language, Senator Moore, is just to ensure that the entire appropriation here is spent and not held back. But
Yeah, I wasn't commenting on what Senator Moore said. Actually, I was more, as I was going down here, there's nothing in here that I don't quite understand how this money is allocated. And Luke, if you're listening and you need to text me this, you feel free. But I can't tell. I mean, it just says increased reimbursement, but
Well, it does refer to using the temporary rate increases. I think the intent is to use the same method that they used for temporary rate increases from March 1 to May 31 last year.
Well, then that's fine. It should probably say that,
Yeah.
and that's okay.
Yeah. Yes, that's right.
Because, we don't, well, anyway, yeah, it should.
This wasn't drafted by one of our crack analysts, was it? That's my point. I can't even get it to print. All right. So what other kinds of questions do people have? Representative Craven.
Thank you, Mr. Chair. I wouldn't be willing to support retroactive funding without having.
We just lost your audio, Representative Craven. Representative Craven, we just lost your audio. We can't hear you. Representative Craven, we didn't hear any of that. If you can hear us, we can't hear anything.
Oh, can you hear me now?
Yes.
Okay. So I was talking about the retroactive piece. I wouldn't be willing to support the retroactive dollars without having our federal match. And as far as the FMAP dollars go, I think that we get those dollars for everybody, not just one sector of service. And just like lumping it together and giving it to nursing homes, in my opinion, is not what it's intended for.
So I think maybe I'm misunderstanding here, but I thought that was the FMAP specific to nursing home charges, that it doesn't come as a lump sum that gets deposited on the front lawn in Augusta. It comes with an increase in what the compensation is per unit of service or whatever.
That's what I understand as well, but I see in the amendment that some of the FMAP dollars are being used to fund this.
You want to speak to any of this, Molly?
Thanks. I really can't. This hasn't been discussed or negotiated with the administration, so I'm unaware of the content.
Okay. And
Can I ask
okay.
a question about the FMAP? I'm sorry, but wouldn't you be getting the FMAP anyway? You don't need to put it into law to say that they would get whatever FMAP they're entitled to. Am I missing something?
No, I think that they should get whatever they're entitled to, but I noticed earlier in the supplemental budget that the FMAP dollars were lumped together and put into the general fund for another issue. So that's what I thought that this amendment intended, was to take FMAP dollars without the increase to everybody else and use it for paying the nursing homes. Maybe I misunderstand. Maybe that Senator Baldacci needs to explain that.
Right, and I wasn't questioning you either, Representative Craven. My question was also to Senator Baldacci and to Molly.
Senator Baldacci?
So I agree that we don't have it right in front of us, what money is still in what accounts. What I was going to suggest to the committee is that we approve of the appropriations. We can discuss what are in the preamble about possible sources of funding. Because there's going to be this has to go to appropriations. There's going to be a whole different, whole wide set of categories of funding that are going to be out there that we might not even be aware of. But I think we could have a discussion in the preamble about the reason for this and what we see as possible sources of funding, and then the actual statute or resolve that we pass could simply say authorize the amounts that we're seeking in order to stabilize our nursing homes around the state. So I don't want us to get caught up in or bogged down in that, because really it's not, as a policy committee, I think ultimately we have to leave it up to AFA anyway as to how it's going to be and under what category it's going to be characterized. So I think it'll be more effective and to the point that we focus on what we see as a need for the appropriation. As far as dispensing checks, obviously we could say, some timetable within 60 days from the date of enactment or something, or the day it becomes law. I mean, it doesn't, or say August 1st or whatever. I think obviously that can be adjusted. But I think I'd prefer us not getting bogged down into the source, because we should keep it as that part of the discussion and then just do an appropriation in the statute. That's my feeling.
Any thoughts about that? Yes, Anna.
I'm sorry, I'm not trying to be difficult here, but I understand that as a committee, you can say we can leave this to appropriations, but I can't leave the drafting to appropriations. That is not an option for me. So it has to be a little bit decided by the committee what it at least should look like.
Okay, I mean, we can't. So what asking you as our analyst, then what are the possible options that we could consider in that regard?
I mean, you have it as a committee, have to decide what it is you want. If it's an appropriation with rulemaking, I mean, fine. But I'm just saying that I can't just say I can leave it to appropriations, whereas I understand that could be an option for a committee.
Well, no, I'm not. I'm saying that we make an appropriation with rulemaking, but I mean the source of the funding because obviously an appropriation could be from general fund or whatever, but I'm assuming that AFA can, if we make an appropriation with rulemaking and then AFA decides it should be under a different category or whatever, I just assume that would be acceptable. But if it's not, then I will.
I'm not saying that it's not. I'm just saying, I mean, you're right about the source to some extent. I mean, Luke still has to know what the source is in order to do a fiscal note. I understand that you want to leave some of this out, and that's fine. But it's up to you. I mean, you would have to decide, how much is going to nursing homes, how much is going to PNMIs, how you want that distributed at some level. I mean, in terms of, I don't know, rate increases based on the TRIs is fine. I can figure out how to draft that. The date thing, obviously, that's, you made a suggestion that that's certainly possible, the 60 days after enactment. I may have more questions as I'm going along. I don't mean going along today, I mean as I'm going along drafting.
Right. No, I gotcha.
So Senator Baldacci, the basic goal here is to have the department allocate $20 million for rate relief for nursing facilities. Is that the single most important thing?
Yes. And then the 12.5.
That the 12.5 being the FMAP?
The
Oh, 12.5, I'm sorry, in section 2, right, yeah. So how about if that section 2, it says the department shall allocate 12.5 million from any remaining available federal funding. Well, it says the same thing. Yep. Yeah, I've never seen a bill written based on speculation because we don't know that those balances are there.
Right. So we don't have to say from any, we can just make an appropriation is what I'm trying to say, because we're in a different, this is an unusual situation.
Sure.
And I think that we're all trying to figure out budgeting with a whole range of different things happening. So I think that if, as a policy committee, I think we would achieve our purpose if we could do an appropriation. We can discuss in the preamble possible sources of funding. And that way give some guidance maybe to what we're thinking to the appropriations committee. But I think that our actual statute only has to, or resolve only has to say an appropriation of money and how it's going to be dispersed. We don't, because ultimately it would come from the general fund if there are no other sources, but we can discuss in the preamble that where we think there is probably available money based on the fact the state's already reported that it's spent 30 million less in payments to nursing homes last year. So so that's where we are, but I think it would be safer if we just did an appropriation and like we would at any other appropriation, and if there needs to be rulemaking, that's great. And we set out some guidance for how we want it distributed.
So you want to leave out language in section 1 that says anything about where the money comes from.
Right.
Okay. And the only other inclusion there would be that it would be dispersed consistent with the method used to distribute temporary rate increases in effect in March 1 to May 31.
Correct.
Use an existing methodology.
Correct.
Okay. And then in the section 2, it's again the same thing. You want to appropriate 12.5, and we don't care where it comes from.
Well, we do care, but we don't have to put it in the statute.
We don't have to stipulate, right?
Yeah. Right.
All right.
And
And
if there needs to be language about rulemaking, then that should be in there. I don't want it not to be in there.
And then the other thing is to allocate the funds, leaving no money unallocated. That's different than unspent. So is that a better terminology, Anna, that the funds be entirely allocated as opposed to entirely spent? Does that leave the department some more flexibility? I don't know. Okay.
I'm sorry, I really don't know. I don't know if this is helpful to you, Senator, but I was just going to bring up the language from 197, I think it is. if I can find it.
Anna, I'm sure it'll be very helpful.
No, I want you to see this. So
No, I'm
is-
serious.
Yeah, no, I'm wondering if this kind of language is somewhere along the lines of what you're looking for. I can
Correct.
probably make it bigger.
Yeah, no, I just did. So I thank you very much. I appreciate, that's exactly what I was talking about. Yeah.
So you would be substituting language such as that for the intent of appropriating $120 million amount and another $12.5 million amount.
Correct.
Because they're going different places. Okay. Representative Craven?
Thank you, Mr. Chair. I'm not happy with the piece that says, can you hear me? Or am I?
Yes.
That we have to spend, that all the money has to be allocated. There are other people who need money, and I don't it's just like so broad, and I've never seen that before, and I don't know why we're trying to put that in there.
If we went with language from 197, which she just showed from Senator Breen, which we approved, would that be adequate? Because it doesn't require 100% spend down.
And that language was more about not knowing whether there was federal money. That's why I brought that up. I don't know that that really answers the question about spending all the money that you've allocated. I actually don't think that's related.
Well, that was contingency money, contingency language too. If it's not there, we can't spend it. Same thing applies here.
I think, Mr. Chairman, if I might, I
Please.
think that language was just about making sure the administration actually spent it, but I'm happy to take that sentence out, or that reference out. I think it's more editorial than anything else. So I think that if Representative Craven is bothered by that and wants that removed, I have no problem with it. I think that would be fine if that got removed.
Okay. Any other comments? Are we getting closer to answer some of the questions that you had, Senator Moore?
Yes, Senator Claxton, you are. I do like the wording from 197 that Anna brought up. I think that's what we're talking about. One-time allocated funds. It will go to appropriations, and that will be up to them to decide where the funding goes. But I think that might be a good approach to it. Plus, making some modifications to the whereas part of it. Some of that does the preamble. Yeah. Some of that's got to be taken out.
Preamble needs to be cleaned up a bit. That's right.
It does.
Editorializing, right.
Exactly. And I think I would be okay with that without all the other words that are not necessary.
And I would be fine with that as well, Mr. Chairman.
Okay. So Anna, as far as the preamble goes, do you want to work with Senator Baldacci and whoever wants to contribute to make that read a little better?
I can figure that out.
Okay. And then Senator Baldacci, as you're concerned with the two specific allocations, you're comfortable with the 197 language?
Yes. Yeah.
Okay.
Absolutely.
And section 3 was about waiving certain audit cost settlement rules.
Right. That was, I think, to avoid the nursing homes getting penalized for taking this money. It's much like the PPP situation we had where they were getting dinged. We just want to make sure they weren't going to be penalized from receiving these funds, because they're really one-time relief money. It's not an ongoing yearly appropriation.
Okay. How do folks feel about that element? I don't see any pros or cons. Okay. Well, any other questions related to this? So as it looks now, the preamble is going to be cleaned up. The two allocations will stand, requests for allocation will stand with language taken from LD 197. And the other parts stay the way they are.
I heard some other things as well. I heard the changes to the dates
Oh, yeah.
Oh, yeah.
and also the existing methodology for reimbursement.
And the methodology was to replicate what was done early last year.
That only
And
works for the nursing homes, but yeah.
What?
I think that only works for the nursing homes. I don't know that that works for PNMIs, but I think existing methodology is fine.
Okay.
Okay.
And on the date,
Luke will tell me.
So let's hear from Mr. Erb. So if we use previous methodology for distribution of funds, would that be adequate on this?
I think it should work. Both the nursing homes and the PNMIs received temporary rate increases in the spring of last year. I think it should work for both, but if there's another problem, we'd be happy to work on that. Just two other things quickly, just for clarification. I appreciate the opportunity. For purposes of the introduction, I'm Rick Erb from Maine Healthcare Association. The $12.5 million that is referred to here, that is the same amount of money that was unexpended for nursing homes in a grant program that came at the end of last year. We got to December 31st. It had not been allocated yet. We had been asking that that money be reallocated this year instead of being allowed to disappear. So that's where that number came from. As far as the methodology, I think it was assumed that that would be worked out perhaps as part of rulemaking, but that we did know that there was work to be done on that, intended to use the last year's method as a guide, as you have assumed. I will say regarding how far back you can go, it has been done in the past where the amount in current quarter has been increased to more or less make up for the first quarter that was missed. So that is a possibility if you're interested in looking at that.
Thank you for that, Rick. Well, I guess we'll go with the methodology that was used to distribute funds early last year. And the dates would have to get pushed out when the money starts to flow, or, you know, as soon as possible or something like that after passage of the bill. Is that? And then we have to decide about retroactive. Yeah, Senator Baldacci.
Well, I was just going to say, in terms of retroactive, if we could leave the language there with a comma, to the extent allowed by law or allowed by federal matching grants, or some sort of qualifier, so that we're trying to go back as far as we can. I think something like that might be retroactive to X dates, comma, to the extent allowed by law or by the rules of the program or whatever. So I just throw that out there. In terms of the payment, I think, yeah, it should be something like 30 days after enactment, if that's possible, or 60 days after enactment. But that's up to the committee. Thanks.
Rick?
Just one other point of clarification. The 12.5 million that we're referring to was originally CARES Act funds. So that's where it came from. It is not eligible for further federal match, but it would need to be reallocated to us as it had been originally.
So we're talking about going retroactive to the point at which, while to the point at which there's federal matching dollars available. That won't let us go outside the quarter for that.
Well, I think, Mr. Chairman.
Yep. Yes.
I think
Senator Baldacci.
I think what Mr. Erb is saying is this money is already there. So we're not asking
No, I
that it'd be-
understand.
That we're not, so we can set the parameters as to how we're gonna pay this. So the 12.5 million is already there, so we can say it can be retroactive if that's what we decide. We don't have to get the federal permission. I think that's basically the content of what he's told us, is that we have the money, it's been given to us. So we're not looking, it's not looking to be matched by anything.
The retroactive language is only in the nursing facility section anyway.
Okay.
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 I guess that answers that. Thank you.
30 days after enactment. Is that something we can work with, or that, do we see it done that quickly for large amounts of money?
Can I ask, I'm sorry, are you saying that the money must be dispersed by 30 days or 60 days after enactment? Is that what you're saying? It's fine, I'm just trying to follow on here.
I'm deferring to Senator Baldacci.
Well, thank you, Mr. Chairman. I would say 60 days. Unless Mr. Erb thinks that sooner than that is, I mean, I'm trying to be realistic about the administrative process, but.
Distribution to begin a lot later than 30 days?
That's why I'm confused. Is the distribution beginning or is it ending? That's what I'm
Well,
confused about.
I'm just putting that on. I'm waiting for eyebrows to go up or down.
I'm hoping that all the money can be dispersed within 60 days after enactment.
Okay.
That's my bottom line, I think.
Okay. Senator Moore.
My only concern would be is that, are we sure we're going to have the money by then? If we say within 60 days, that's my only concern about putting a parameter on it.
I did see available in the language in 197.
Okay.
But Anna can correct me if I'm wrong about that.
I think that that's possible, but yes, that was what I was saying, Senator.
Okay.
Okay. Yeah. Yeah. If it's not there, you can't very well distribute it, and you don't want to break the law. Yeah.
Okay, I'm sorry, I have another question. So
Sure.
Are you prepaying rates here? That's the other thing I'm a little confused about. If you disperse it all within 60 days.
Well, maybe Rick Erb could address that.
Let's go to Molly. We haven't heard from Molly yet.
I just wanted to echo that question. I'm not sure how, if this is a rate increase, I'm not sure how we're supposed to get all of the money out of the door in 60 days when it's an, temporary ongoing increase for services rendered.
I think the idea of it was to have it paid out in a lump sum to cover a particular period of time. But maybe
I'm going to bring it up again, if that's all right, because it has this language of December 31. So I think that's where Molly's coming from, and she actually saved me there. I didn't actually think of it. So I think that's where we're confused, is that you want all of the money dispersed by 60 days afterwards, but the increased rates go through to the end of the year. And I mean, wouldn't that depend on how many people you have in your nursing home or at PNMI or whatever, and you wouldn't know that ahead of time.
Well, it's a set amount of money. So the money is not going to vary because we're doing a specific amount of money. So it's not going to, so if they have reduced, the whole point is that because of the cycle of having reduced occupancies, therefore less money. So we're trying to be counter-cyclical and give them these increased money. So the intent would be a lump sum to cover an increase for a specific period of time.
Well, then it isn't a rates bill. It's not a rates bill then.
Mm-hmm.
You just changed it.
Well, it's still, yeah, okay. I'm not going to get into that. That's whatever the committee wants to do.
Now, I think you can talk about a one-time grant when it comes to the CARES money related to PNMIs, because that's felt to have already been appropriated and not distributed. That could be done as a one-time to provide immediate relief and to avoid facility closures, quote unquote. But if you're talking about a rate bill, then you're really looking at distributing the increased rate over X number of months ending December 31.
So maybe the amounts that are owed through June 30th can be paid if we can differentiate the retroactive amount versus the ongoing payment amount.
Senator Perry, Representative Perry, sorry to demote you.
Okay, this has gotten extremely confusing. And quite honestly, if we're going to do a rate bill, we can go back to the quarter beforehand. That's federal funding. And then move forward as a rate bill. You know, I don't think the nursing homes are looking for a windfall all at once. And I think that let's leave it as a temporary rate bill. Let's get it in as soon as possible so they can begin the work on changes those rates for that period of time.
And that's fine.
Leave it as a rate bill. And remove any language that talks about paid out by or distributed by. Thank you, Representative Perry. Any other points to make? Any other concerns, questions? So we've gotten rid of the dates other than whatever we need to. So I'll go back to Anna. What other questions need to be resolved before you do your crafting?
I don't know. I think I'll probably have questions as I draft it and I can always bring them back. That happens all the time.
Sure.
It's not unusual.
Sure. And you certainly have endorsement to work with anybody who can help you craft it.
Do we need to do a motion, Mr. Chairman?
What did you say?
What kind of motion would you like to entertain? I mean, do we want to table this, or do you want to approve it as amended based on the discussions, or how do you want to proceed?
What's the sense of the committee? Does the committee ready for a motion? Yes, Representative Perry. As soon as you're unmuted, Representative.
I'm going to do a motion. Let's see what happens. I'm going to move ought to pass with the changes in the emergency clause, using this as a temporary rate bill that would start up as soon as the emergency that gets through. Still has to go to the AFA no matter what we do. And we can make it retroactive to the quarter that either we're in or before. I can't remember how that would go. As long as, you know, making sure that we have the federal funds to match. And that's it.
I would second that motion.
Using LD 197 language.
Yes.
Yes. Okay. So there's a motion on the floor. Is there a second?
Second.
Okay. And any further discussion? Representative Perry, is your hand up again or still? Okay. So we'll go to Ms. Withy then and get a vote on ought to pass as amended.
Representative Zager.
Yes.
Representative Zager. Yes. Representative Lumlin.
There we go. Yes.
Representative Lumlin. Yes. Representative Stover. Representative Stover is absent. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Griffin.
Yes.
Representative Griffin, yes. Representative Connor. Representative Connor is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Javner. Representative Javner is absent. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes. That's 10 yes, 3 absent.
Okay. So, Anna, I know there's some other things to do, but how do you feel about going to the public hearing as of 3:30? And then after that?
Could I, because I don't know, I never know whether Senator Baldacci is going to be available or not. Could I get him to go on the record for 1427 right now? This is an act to encourage family care of aging adults. This is a bill that you voted or not to pass last week. It's the estate recovery bill. My understanding is that Senator Baldacci cast a different vote and he needs to cast it in public to say what his his report is.
Mine is ought to pass as amended with amended for a fiscal note.
Thank you.
Representative Griffin?
Yes, can I do my votes that I missed this morning?
I think, yes, you can, certainly.
Okay,
As soon as Carrie is ready.
okay, thank you.
And then we'll take a break until 3:30. Those of you who don't need to listen to Representative Griffin vote should feel free to step away from your computers or stand up and move around, and we'll reconvene at 3:30 to hear from Representative Millet.
Representative Griffin, do you need me to go through the LDs?
I think I have it. LD 1548 ought not to pass. LD 1392 ought not to pass. LD 6.
Oh, one moment. Sorry.
Okay.
Let me write that down.
I'm sorry, I didn't mean to go too fast.
Okay.
Okay. LD 1695 ought not to pass. LD 629. Are you okay, Carrie? I don't mean to go too fast.
Yes,
Okay.
629.
629 ought to pass as amended. And I understand that 1608 was tabled. Is that true?
That is
Yes.
correct.
Okay, thank you.
Thank you.
Okay. Don't give up, Representative Millet. We'll be back. So the chairs and leads scheduling meeting this afternoon should be pretty quick. We're running out of things to schedule.
We do still need a quick one though.
Yeah, I do. I understand. And there's some other stuff to finish up at the end. So it being 3:30, we said we'd reconvene so that we could hear LD 1701, an act to establish a managed care program for main care services. We're joined by Representative Millet. Welcome, sir.
Thank you, Mr. Chair. You ready to go with testimony?
We're ready to go if you're ready.
All right, thank you. Senator Claxton, Representative Meyer, and distinguished members of the Health and Human Services Committee. I am Representative Sowen Millet, and I'm pleased to present for your consideration LD 1710, an act to establish a managed care program for main care services. LD 1701 proposes to modernize and reorganize the state's main care services through the establishment of a managed care program. Establishment of such a program aims to ensure high-quality outcomes, patient satisfaction, and access to care, as well as ensuring budget predictability through shared risk and accountability. Managed care in the Medicaid world is a model in which a state hires health insurance companies, also known as managed care organizations, abbreviated to be MCOs throughout my testimony, and their role is to administer the Medicaid program. In this model, DHHS would hold MCOs accountable for service costs and health outcomes, giving time and resources back to the state to focus on other important matters. Managed care is not a new concept to Maine. More than a decade ago, the Governor Baldacci administration was poised to move to a managed care model, but the new administration changed course and instituted a different policy. In fact, in 2014, the legislature did pass legislation directing DHHS to implement managed care, only to have the bill vetoed by then Governor LePage, and that veto was sustained. As a former DAFS commissioner and a long-term member of the Appropriations Committee, I'm keenly aware of the pressures faced by our Medicaid program. It seems like every year the AFA committee wrestles with the cost of the main care program, and each year the cost of the program increases. We currently spend approximately $3 billion annually, with little emphasis, from my perspective anyway, on proactive health measures and/or prevention. This existing fee-for-service model is unpredictable, costly, and doesn't always produce the best healthcare outcomes. It is clear that the current model doesn't work for main care enrollees or for Maine taxpayers. As you may know, many other states have grappled with these same problems and have implemented managed care as a way to address these significant issues. In fact, 38 states and the District of Columbia currently contract with MCOs, including our neighboring state of New Hampshire. With so many jurisdictions using managed care, there is much experience we can glean from, and I would encourage the committee to look at those states with proven results. This bill was designed or intended to build on some of the best practices. However, the language as it is printed is a bit more prescriptive than I had anticipated. The bill has been in the reviser's office for some time, but in an effort to get it out and printed when I was contacted 10 days ago, I simply reviewed it and signed it so it would get in print, realizing that you folks, as all our other committees are, up against deadlines to hear and work on bills. So this is essentially a first draft, and I provided to your staff an amendment that I would suggest was worthy of your consideration, probably not in this week with Friday's deadline, but in the event that you choose to carry it forward. It would take away some of those prescriptive requirements and rely more on the department to design the scope and content of an RFP and move forward. with timelines that would have to be modified. As presented, this would require DHHS to establish a managed care program starting in January of next year. That is an unlikely timeframe given the lateness of consideration. The department would maintain the ability to design the main care program under the amendment and determine the contract terms under which the MCOs would operate, as well as review detailed proposals and choose, as proposed, multiple MCOs to fit the state's unique needs and generate innovative solutions. MCOs would be contractually obligated to provide all medically necessary services, and it is common for them to offer additional services at no cost beyond what is required by contract. MCOs are paid in a risk-based financial structure that encourages them to promote the health of the main care beneficiaries they cover, which encourages them to invest in improving the members' health and social determinants of that health. With this arrangement, DHHS and the MCOs have a mutual interest in meeting these outcomes, both quality goals and ensuring a sustainable delivery system. I recognize this is a departure from current DHHS practice, but it is my belief that this policy change would result in greater budget stability and improved health outcomes. The per member per month capitation helps protect the state from unpredictable healthcare costs and helps reduce fraud, waste, and abuse. And the use of quality measures based and focused on preventive care and value-based purchasing, as well as the ability to address the social determinants of health, could and would lead to better overall health outcomes. Finally, given the lateness of the session and this bill coming to you, I am respectfully requesting that if you feel it worthy, that you would consider carrying it forward with the proposed amendment for the next session consideration. Thank you for your thoughtful consideration as well as your timely scheduling of this bill and consideration of my request for a carryover. I would be happy to try to answer any questions you may have, but I know there will be people testifying after me who are well-versed in the mechanics and nuances of Medicaid managed care, and they are better positioned, I'm sure, to provide answers. Thank you for your consideration. And again, I want to help you as a committee consider this, and will do what I can to further that request. Thank you.
Thank you, sir, for bringing this forward. This is a topic that's come up in the committee already somewhat in the form of value-based purchasing, but obviously justifies a whole lot more consideration. So thank you for that. Representative Craven has a message of greeting.
Thank you, Mr. Chair. Thank you, Representative Millett. I was here when the department was working on managed care before and was very interested. The biggest question actually I have is whether the medical transportation would be under the managed care as well, as opposed to brokers like we have now.
Representative Craven, I'm going to say I would assume the same as you do, but I would want that question to be answered by those that have had experience working with a total care system. So I'm not wanting you to take my word for it, but I definitely think that's a question you should pose to the people that will follow me.
Thank you.
Any other questions for our presenter? Not seeing any. Well, thank you again for being here, and thank you for being patient through an afternoon that went quite a bit later than we thought it was planning to, but you know how it goes.
I found it very interesting, so thank you for your patience as well.
Interesting is a safe word. Okay. We also are going to hear from Joel Menges. I'm sorry if I've messed up that last name, sir. Welcome.
Hey, thanks for having me. And I submitted testimony, PowerPoint slides in writing that you can avail yourself of. You don't look like a group that's welling up with a lot of extra time as I've watched your deliberations today, but that's there for you if you want to go there. I really appreciate the chance to talk, and I also just want to call out Carrie Withy, assisted me in overcoming my own technology challenges to get plugged into this, and I really appreciated the spirit that she had patience with me, and the effectiveness with which she got me plugged into this. But that's kind of analogous, in my view, to what this bill will do. The
Could you
main care
introduce yourself?
population. I'm sorry.
Could you introduce yourself and your relationship to how you happen to be here speaking in favor of?
Of course, yeah, sorry. So Joel Menges, I head up a consulting firm named the Menges Group. I have worked for the past 30 years in the Medicaid managed care arena, about half and half supporting states as a consultant, and about in their design and development and strengthening of their Medicaid programs, and about half on the health plan side, helping them design and strengthen their programs at the street level to deliver coordinated care. Is that enough for I
That's
can
fine.
go on?
Thank you. That's fine.
Sure.
Just context.
Sure, thanks. And one other context, I'm not intimately familiar with Maine's program. I've looked at a lot of data points and so forth, but there's a lot more that I don't know than I do know about Maine's program. So I'll be speaking more from a national perspective about the 40 states that have adopted this model in some fashion and so forth. But anyways, back to Carrie. So she helped me overcome my issues, and I think that's analogous to what's needed for the main care population. They are not in the best position in terms of in terms of being able to access care, their life circumstances, their housing and nutrition needs, and so forth. And they need help, more help in the 99% of their lives where they're not accessing the healthcare system. And in the absence of that, I think the pure fee-for-service model is breeding low birth weight babies and chronic conditions that don't get addressed well enough, and you end up with a lot of crisis point care that can be literally tragic clinically, but certainly problematic clinically, and also just very cost ineffective when you're dealing with the hospitalizations and the ED usage that could have been averted by upfront care and by supporting people in their health behaviors more. So the model that this bill is designed to do is to engage with people in the 99% of their lives when they're not in the system, and try to coach them into a better way. And I think that's much needed, and the evidence around that is compelling in terms of the quality metrics. Quality is going to be measured much more intensively and tracked, and there'll be sort of an open book test of these people aren't the ones getting care, and the health plans have full control over how hard they work to engage with those people to get them in, and what the specific needs are, and how to help with their housing circumstances and so forth. You just don't get that now with a fee-for-service model that understandably is structured to pay claims and deliver a benefits package to people. But the lesson of the other states is that a modernized program, is the word that Representative Millett used, is better, just flatly better in terms of what it's bringing to the table on access, quality, and cost dimensions. The other thing I just wanted to talk about is the competitive procurement aspect of the bill. It's there is a cadre of sophisticated Medicaid-focused health plans out there that you can kind of put in a lion's den and have you design the RFP with the questions you want and the things you want them to compete about, and you also control how high the bar is just with your sheer contract requirements before you even get into the RFP questions and the competition of who's going to be innovative. But the plans will come. These plans are excellent and committed to what they do, and they want to grow. And there's 5 states, smaller than Maine in terms of annual Medicaid dollars that have these programs and have had very successful competitive procurements and many more applicants than what the state has awarded. So you can tap in and kind of leapfrog to the best of where the industry has arrived at through the past decades of doing this work in Maine, rather than evolve your way there as the other states have had to do. So yeah, I feel very confident that this model will greatly strengthen the program for your beneficiaries and your taxpayers.
Thank you, sir, for that introduction. Are there any questions of Mr. Menges? Yes, Representative Perry.
Thank you. I was just reading through some of the other testimonies and testimony that came up from the Autism Society, which really expressed some concern about capitation and contract with it and MCOs. What are your view about those concerns?
Sure. So I've, like I said, I've got decades of doing this, and the industry started out serving sort of, if you will, the moms and kids side of Medicaid, and didn't serve the aged, blind, disabled, the kids with autism, and so many more kinds of real high need, high cost subgroups. And I think that's been a mistake, because the degree to which you can change the trajectory and make favorable impacts in those higher need populations, and unfortunately in a way, but fortunately from a care coordination point of view, if you have these disabilities, you're going to have much more continuous enrollment. So the health plans have much more long-term ability to connect and make a favorable impact with a child with autism than they will have with sort of I hate to say, a regular TANF enrollee who's in and out in 13 months, but of coverage. But I think we can, I'm happy to come back to you with the evidence around this, but there's compelling evidence that the higher need subgroups can be served much more effectively in a system of coverage. And again, if you're worried about specific subgroups, have questions about how the health plans will deal with them and what commitments they'll make to deal with them in your RFP and in your competitive bid, and make sure you're getting what you want there, and that you're putting them in a competitive position to elevate what you're getting above what your requirements are. But that's available to you. And I think, a lot of people who throw darts at Medicaid managed care haven't really seen it. There's allegations that they're there to deny care and they're going to make money that way and so forth. And that just isn't what I see happening. And I think, I've got teenagers. I asked them, or had teenagers. I asked them at one point, if I had a camera on you 24/7, how would I feel about you? And they both rolled their eyes like, oh man, I don't want that. I don't need that. You wouldn't be real thrilled with me. But honestly, I think the naysayers of Medicaid managed care, if they really had a camera on the whole health plan 24/7 and see the totality of what they're doing, they'd be advocates of it rather than opponents of it.
Thank you.
Any other questions? Can you give us some idea about a typical cycle to go from we're beginning to work hard on this to we have our first plan and enrollees up and running? Sure. I think your Medicaid agency has worked with Manat, and I don't want to get into the business of advocating for specific, consultants or whatever, but they have tremendous ability to design a Medicaid managed care program, contract requirements, help draft RFPs and so forth. But that will take, many months to get in place. And there needs to be confidence that there's a legislative, approval of the program for these things to get, so you guys control the moment of legislative approval, obviously. But once that exists, I'd say you need a good 2 years before you have actual health plans under contract serving members. Because the procurement process takes a while to get every stakeholders comfortable with the design of the program and what the procurement's going to have in it. And then the plans need time to bid effectively. You don't want to create a competition around, who can run 100 yards the fastest with their bid. You want to give the plans a chance to be thoughtful about that. And then you need time to review and score the applications and pick your best partners. And then they need time, the winners need time to get up and running. So
I'd say that's 2-ish years typically.
Yes, Senator Moore.
Thank you, Senator Claxton. And thank you so much, Mr. Menges, for testifying today. Just one question. What are your views on an accountable organization framework relative to the Medicaid managed care model?
Yeah, it's called an ACO is the acronym for the Accountable Care Model. I think the main differentiator in an ACO setting typically, and there's different kinds of MCO contracts and there's different kinds of ACO contracts, but the general differentiator I would give involves administrative, acumen and effort and sophistication. One example I would give is a member with a lost ID card calls into the health plan's member services department. And oftentimes what you'll see in today's, with the health plans that serve Medicaid is while the customer services representative is serving that person and getting the ID card figured out, the screen will flash and say, the second child of this member hasn't gotten their EPSDT screens yet. And so the person, while they're talking to the person about the ID card, will engage with them about getting a pediatrician visit set up and often schedule a 3-way call with the pediatrician's office to get a date and schedule transportation, which you guys mentioned earlier is a key part of all this, and get all that tied up and then follow up to see that visit is, a couple days before is occurring, and maybe follow up afterwards to see how it went and so forth. But, an ACO, there probably isn't even a member services department to call in the first place about your ID card, let alone all the other things I rattled off. So it's just there's a tremendous disparity in the degree to which you reach out and connect with people, like I said, in the part of their lives where they're not in care already, between those two models typically.
Thank you.
Okay. How about other questions? Well, thank you for being here. Thank you for bringing your expertise and sharing those slides that you sent ahead.
Thank you
Lots
very
to
much.
learn.
Good luck with everything.
Lots to learn. So also speaking in favor is Kimberly Cook. Welcome.
Thank you, Senator Claxton and members of the committee. I'm Kim Cook. I'm here on behalf of Community Health Options, testifying in support of LD 1701. Community Health Options is Maine's only nonprofit co-op health plan, and we are based in Lewiston, and we exist for the benefit of our members and our mission, which is to provide affordable, high-quality benefits that promote health and well-being. We support this bill, and this support is grounded in our deep understanding of the value and benefits that a proper managed care model can deliver to both the state and to Maine Care members. The state is involved with important efforts already to achieve the triple aim through its Maine Care program, and LD 1701 will amplify those efforts and open the door for Maine to realize the benefits already achieved in a majority of states throughout the country. In much the same way that Medicare Advantage has successfully brought additional services and supplemental benefits to Medicare enrollees, Medicaid managed care taps into the expertise that already exists among health plans like ours to serve as an extension of the goals and aims of Maine Care. Utilizing the expertise that health plans have in the area of care management and coordination, and working with members to help them access the right care at the right time serves to improve health outcomes. A quality managed care approach would also serve to ensure that the social determinants of health are addressed as part of Maine Care benefits. This is critical in promoting health and well-being among Maine Care beneficiaries. Moreover, the value to Community Health Options is in serving the population, whether the population is accessing coverage through the marketplace or through Maine Care. We have always been proponents of a healthy and robust Maine Care program, including expansion, on the basis of our belief that adequacy of coverage for everyone in the state is vital to the health of the marketplace, as well as the health of our economy and people. As a mission-driven nonprofit, Health Options is focused on improving the health and wellness of populations that we serve, as well as being a positive contribution to the health and well-being of Maine. And we would encourage the committee to carry the bill over if you're so inclined to consider it and consider the amendments that the sponsor has brought to you. And with that, I'd be happy to try to answer questions or bring information back to your work session. Thank you.
Thank you. Thank you for that. Are there questions for Ms. Cook? Do you want to take a minute to brag about community health options and the not-for-profit status and how well you're doing overall?
Given how long your day is, you probably don't want to extend me that offer, Senator. But Health Options, as many of you know, has been an active participant in Maine's health insurance marketplace since 2014. We're actually the only insurance company that has been offering individual coverage through the marketplace every single year here in Maine. And as many of you had watched in the early days of the Affordable Care Act marketplace, there was some tough going across the board for both for-profit and nonprofit insurers. And I am happy to tell you that those days are behind us, and we are financially strong and secure. Our members are very happy. Our board, as you may know, as a cooperative nonprofit health plan, has members that have the insurance on the board, so they help to make the decisions for the health plan, which I think is part of our strength. And we do have a very mission-driven approach to the service that we provide, and we are pleased now to be not only offering individual, small group, and large group fully insured insurance, but Health Options has started Pioneer ACO, Administrative Services Organization, that is providing health plan administration to employers and groups that are self-funded. So thank you for that opportunity, Senator.
Sure. I don't see any other questions, so thank you for being here.
Thank you.
I also don't see anybody else who's wanting to testify for, and nobody who wants to testify against. We have a couple people neither for nor against, so let's hear from Jeff Austin.
Good afternoon, Senator Claxton, members of the committee. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association to speak neither for nor against the bill. Our policy committee did not have a chance to review the bill. It sort of was printed and heard before they've had a chance to meet, so we're testifying neither for nor against. My written testimony, which you have, is essentially the exact same written testimony that I provided in 2013, which is, I think, the last time this was really discussed in detail. Our members are not dead set against managed care, but they do advise you to go into this with open eyes. You know, what are you trying to solve? What challenge do you think actually exists? And we respect that Representative Miller has been around and seen this issue from each side, front and back, for several decades. But we're not so sure there's a problem here that needs solving, and we'll get to that in a second. There is not a lot of research out there about managed care. You can see from my testimony, the best thing we could find in 2013 was a Robert Wood Johnson Foundation study. And they took on some of the questions posed by managed care. The big one being, do you save money? And there's no consistent evidence that managed care states save money. Do some states with managed care save some money? I think the study said that they did, but it's pretty variable and not very consistent. What's more concerning, and you can see this at the bottom of page 2 of my testimony, is when they found savings, how were they achieved? Through managed care, by getting people in early for screenings and all the wonderful promises that you hear? Robert Wood Johnson did not find that. What they found was, and I quote, "The cost savings are due primarily to reductions in provider reimbursement rates." When we talk to our colleagues around the country who are in managed care states, they all tell the same story. The managed care entities promise to manage the program, and when they fail to do so, they manage the providers by cutting rates and nickeling and diming on claims, just like any other commercial carrier does. Prior authorization, denials for a missing code, and all the stuff that we hear about in the insurance committee. So that's our concern. And if you're to move forward, we would say, make them make their money through their promises of better care and expressly prohibit rate cuts, rate reductions, and that kind of nickel and diming. The other point we made a few years ago was, and you all know this, is that the 80-20 rule in healthcare, 80% of
seconds, yeah.
Okay, 80% of expenditures are among 20% of the population. Challenge these managed care companies to take them on, because the converse is not often discussed. 80% of the population costs about 20%, $1,000 a year. Why do they need the hassle of management? They're not overutilizing, they're not overspending, they're not, why throw 250,000 people into a program that don't need it? I have one last point, but I know I'm out of time. It's up to you whether you want to let me make it.
What was your last point, Mr. Austin?
I appreciate that. We support managing care. And some of you will remember in the last administration, what became trendy was the hot spotting. Literally find your most expensive members and tackle them. It's often with social services. And Maine Care did that. I forget how many they took on, but it was 100, 200, literally the 200 most expensive Maine Care members show up in the emergency room, not 3 or 4 times, 50 or 60 times. And through managed care principles, we're able to knock down those costs. We didn't see any money from that. We actually lost money from it, but it was the right thing to do, work with the department to tackle those costs. It can be done without a third party that needs to make a buck themselves. You know, they need to pull money out of the system, or else why would they do this? So it can be done. I think the department has experience with this, current members of the department. So with that, I'll wrap up. Happy to take your questions. And if you do carry it over, happy to participate in any conversations over the summer.
Thank you. Any questions? I'm not seeing any. So again, thank you for being here.
Thank you.
Now we'll go to Mallory Shaughnessy. Welcome.
Thank you, Senator Claxton, Representative Meyer, members of the Committee, Health and Human Services. I am Mallory Shaughnessy, a resident of Westbrook. You may hear a bunch of noise outside of my house. Sorry about that in advance. Lots of activity going on out there. I am the Executive Director of the Alliance for Addiction and Mental Health Services. And on behalf of the Alliance, I too am here to share information regarding behavioral health and managed care under Medicaid, or as we call it, Maine Care. But we are weighing in neither for nor against. Given the quick turnaround of the bill's printing and scheduling for the hearing, we did not have an opportunity to fully review and discuss. As referenced by Representative Millett, Maine is in the minority of states by not having already implemented managed care through these types of MCOs. One reason I think has actually been due to our size and the impacts of economies of scale. But some smaller states, smaller population states, and large geographic area states have also found ways to do it effectively. I would share, though, that there are very mixed results in these other states, especially as pertains to behavioral health treatment and recovery. Some states have created truly comprehensive and supportive systems of care for mental health and substance use services. Other states have starved these services to near death, in fact, many times leading to death of members' clients. The history is a mixed bag, but there are some promising practices and successful models to learn from. I did submit already a publication by the National Council on Behavioral Health, which is now the National Council on Mental Wellbeing, that's called The Transition of Behavioral Health Services into Comprehensive Medicaid Managed Care. In this review, you'll read a lot about carving in and carving out as pertains to behavioral health services. Most states carved out behavioral health services when they went to managed care organizations, but are now in the process of many of them carving it back in. There's a thorough review over what that looks like and what the successes and failures have been. This is a critical area. Behavioral health can be severely impacted in a negative way by the way that it is carved in. So we would urge if there's going to be work further on this, I will be submitting my testimony, but we would urge thorough review. I'm submitting written testimony with some more highlights and some other research that has been done. I would urge you to take time to look over. I would concur that carrying this over at this late date would probably be the best situation. And we would hope to be involved in any discussions, because behavioral health is really needs to be critically reviewed before you move into this type of a system. So with that, I will end my comments. I will submit something in writing, and I've already given you some information. And I'd be happy to get more information if you do go forward to a work session.
Thank you for the offer. Are there any questions for Mallory? I'm not seeing any. So in the absence of anybody else to testify, I think that'll conclude the public hearing portion of LD 1701. Senator Moore.
Yes, thank you, Senator Claxton. In view of the testimony today and all the work that remains on this, I make a motion that we go straight into work session to address LD 1701.
Second.
So we're now in a work session for LD 1701. Our options are to fix this small bill or to carry it over. Senator Moore, did you have your hand up again?
Yes, I did. I would make the motion that we table LD 1701 and carry it over. Can we make the same motion all in one motion?
Yeah.
Okay.
We'll start with tabling.
All right. So I would make the motion that we table LD 1701 at this time.
Second.
Moved and seconded. Any discussion about that? All those in favor of the tabling motion, please put up your palm. That is unanimous of those present. So we have tabled LD 1701, and there's a process just for general information that gets things onto the carryover list that, to my knowledge, still hasn't been published yet, but will be soon, and we'll then take that step. All right. Well, thank you. We had some more things to touch base with, according to Anna.
I think we have a number of amendment reviews. I'll wait until you've done amendment reviews to bring up my issue.
Okay. All right. So Erin, are you doing amendment reviews?
I am. We have 4 or 5. I don't remember.
And when we get done with this and hearing from Anna, then we'll have a chairs leads analyst meeting to finish up scheduling, hopefully. All right, go ahead, Erin, when you're ready.
The first one is LD 996. This was a unanimous committee report. You can see here that it's striking out the provisions relating to the stakeholder group. So you see that at lines 11 through 15 are the 2 areas where the stakeholder group would be mentioned in the context of developing a rate. And it also adds the Perry amendment on the second to last paragraph. The fiscal note is attached here. It indicates general fund appropriations in the amount of approximately 1.1 million in the first fiscal year, and then 6.5 in fiscal year 22-23 with a federal match.
Are you okay with that?
LD 1333 is the bill that deals with naloxone and the PMP. So the title changed to expand it to the Controlled Substances Prescription Monitoring Program. You added an emergency preamble. This is where we do a little bit of creative writing. So if you want something different, we can do it. We always are a little out on a limb with these. I think the title needs to be fixed to dispensing naloxone, just like the term dispensation was changed to dispensing in section 1. So I'll fix that before it goes back. to their advisor's office. Section 2 is the PMP piece. The other sections are still relating to naloxone, and those are consistent with the draft you saw at the work session. And there is no fiscal impact. The next bill is 1009. It's the working group. Well, it was about creating an ombudsman position to serve the main county jails, but it's been the goal has been changed to create a working group to design jail resource navigators in the main county jails. Just to note, we did add it to be navigator services, so that like navigator wasn't kind of hanging out on its own. So I hope that that is okay and meets the committee's intent. I worked with Representative Madigan, like you authorized me to just clarify some of the members. The one that I remembered in particular is paragraph 4. We just needed to clarify who she was intending to pull in. Just a note here that I tried to keep it New Mainers population, but I guess unless we were referring to a specific program like the New Mainer Resource Center, that's not the preferred term, and the preferred term would just be immigrant populations. So that's how I'm going to send it back unless there's another suggestion from the committee. And a fiscal note is required, but it indicates a minor cost increase that can be absorbed within existing budgeted resources. LD 1076 was the sister bill to LD 81 that you saw last week. This was about the homeless shelters for children. This is the appropriation in association with both the shelters for homeless children under Chapter 8 and I think in the emergency shelters for homeless children under Chapter 9 of the rules. So the only change to this bill, well, it was a strike and replace. The language went forward in 81. The appropriation is the only thing contained in 1076. And the initiative language was changed to clarify that it applies to facilities under each of those chapters, not just one of those chapters. And so the fiscal note looks pretty much identical to the bill because the bill is just an appropriation. Last amendment for review is LD 1113. This was a divided report. A couple of things here. In the second paragraph here at lines, so this is the majority report, lines 12 to 14. And section 2. Section 2 is where you also authorize your committee to report out legislation. The resolve as drafted authorized the permanent commission to report out legislation. So we just added that into, I think the emergency preamble is lines 12 to 14 to just clarify that the permanent commission isn't the only body authorized to report out legislation to meet the committee's intent with section 2. The revisor's office noted a technical change to not, I guess it's the preference to not hyphenate certain terms. So the term African American is only changed in the context of removing the hyphen. But otherwise the emergency preamble in that regard remains the same. The majority report is identical to the minority. I'm sorry, the minority report is identical to the majority report, except for the provisions at line 21 through 23, which changes the scope of the study by the permanent commission to include the disparities in prenatal care for the state's racial, indigenous, and tribal populations, and instead focuses it on all disadvantaged populations. But in other respects, it's with the report back and the technical changes is identical to the majority. So if those are good, I can ship them out the door.
I don't see any comments, so that sounds good. All right, so we've completed our amendment reviews.
Okay, so one more thing. If you remember back to the conversation that you had with Erin about PFAS and resolve language, we have a similar problem for the ambulance language. And I should have caught this when it happened. I fall in this hole every single year. I try to only do it once. Hopefully this is it. So I'm going to bring up the language and you'll see what the problem is, or I'll explain what the problem is. So this is the ambulance language. Now see the problem here. This is the bill you stuck it in. This is Representative Craven's resolve bill to, it doesn't matter what the bill did because you used this one. However, it's a resolve and this is statutory language that can't go in a resolve. So I did think about how you could fix this. This first section here is actually existing law. This was a repeal and replace, if you remember. So this first section of existing law, it tracks the Medicaid rates for ambulance with Medicare, and the part that you were adding were the add-ons for rural, super rural, and urban. So you have a couple of options to fix this. The second part of this bill was the PT and OT, just to remind you what this did. So you have two options as I see it in terms of ambulance. The one is you can find another bill that is an act and put it in. The second is this language could go in rulemaking, unallocated language, just going down here to PT and OT, just for example, this is telling the department to go ahead and amend the rules to do X, Y, and Z. You could have rulemaking language directing the department to reimburse for the add-on supplements that are currently in Medicare law that apply to Medicare rides for rural, urban, and super rural. And I don't think that that's a particular problem. It's slightly cleaner to have it in allocated language in the statute, but in reality, this is about rates and add-on rates. So that would be the other option. But I need to know what you would like to do. I'm sorry about that. It's a mea culpa. What would you like me to do?
Any thoughts? Representative Craven.
Thank you. I think putting it in rules.
It's fine with me as long as the whole committee is good with it. I think it does work. I got a call yesterday from one of the ambulance association folks, not the ones that came to the work session, and we talked about it after I had finished cursing at the fact that I had made this darn mistake. And I do think that it would be an appropriate way to do it as long as you're okay with that. If you're okay with it, I don't think it's necessary to revote it. If you're not okay with it, then we have a different problem.
So favorability survey with the committee, thumbs up. Everybody's okay with this approach to putting it into rulemaking? Very good.
I mean, they would be doing it in rules anyway. It's just that we were putting the requirement in the statute and then saying, go make the rules to put this there. So I think it's okay, but I'm still annoyed with myself for missing it.
So hard on yourself. All right. Any other? Carrie, you had your hand up earlier. Yeah.
Yes, if everyone could just check their email today and see if you have any emails from Casey Milligan from the Legislative Information Office. And if you have any that you haven't replied to, if you could respond to those today, that would be greatly appreciated. Thank you.
And if you could respond to those without responding all, then I'd be grateful too. Because some of you just need to respond to Casey and not let everybody in the legislature know that that Casey has your vote recorded right. So if you can make that real specific, it'll help my inbox, which is about ready to pop.
I thought it was like voting and that we had to do reply all.
You don't have to do that. You just have to let Casey know the vote's been recorded accurately.
And you risk not just getting a Yoda meme, you risk getting a Grumpy Cat meme. I'm ready.
I feel very grumpy about it anyway, because I'm like, I think I responded to this, but I keep getting more, and I'm like, you're driving me crazy. Like, just seriously, someone stop and fix it.
And I know where you live, Representative Craven, so if you keep sending those every time we vote, there's going to be consequences.
I got it now.
Okay. Right. Thank you for that, Carrie, and for the opportunity to bring that issue up. Any other points? So unless we learn otherwise, folks, this was the last of the really, really hard days. So thanks for hanging in there. We're getting there. So we'll wrap up now. I'll entertain a motion to reconvene.
So moved.
Thursday at 11. I hadn't finished the phrase yet. Yeah, Thursday.